This is Christian attorney R.L. Johnson. I have over a dozen years of litigation experience that is assisting individuals and businesses dealing with difficult times and also with debt collection. I have put together a 4-part series in managing debt and managing crisis financially in the COVID-19 era. This is part 1 of a 4-part series. In this particular part, I want to talk about actionable strategies. In part 2, I want to talk about the consequences of debt relief collection. That is, debtors versus creditors. What are the rights debtors have? What are the rights creditors have? In part 3, I want to talk about Chapter 7 bankruptcy. And that'll be an overview of the Chapter 7 bankruptcy process. In part 4, which will be the final part, I want to talk about Chapter 13 bankruptcy, and that too will be an overview of the bankruptcy process. So what are some of the impacts of the COVID-19 pandemic? In particular, you'll find in businesses there are a lot of issues with regard to breach of contract. You have suppliers who may not be able to meet their quota. You have people in retail who may not be able to pay their suppliers because there's no income coming in. So 2 aspects of breach of contract have become very prominent in this era. One is force majeure. Force majeure is a contract term usually referring to incidents that occur that are beyond the power of the individual or the parties involved in the contract. It essentially means a superior force has intervened such that performance becomes impossible. Typically it's reserved for acts of God, hurricanes, tornadoes, things of that nature that might impair a party's ability to perform. But it's started to rear its head now because a lot of businesses are saying, well, if the government shuts me down, then I am not able to perform or execute my duties under the contract, so a superior force has in fact intervened and made it impossible for me to perform. So force majeure has become a major issue that's being litigated and discussed in legal circles quite a bit. Most nations, most parties to contracts with the United States, for example, do not imply a concept of force majeure into a commercial contract. There are very few countries that do. In fact, one of the countries that does imply force majeure into a contract, a commercial contract, is the People's Republic of China, strangely enough. But the United States, there's no state in the Republic that has within its state statutes, to the extent I'm able to, from my research, discern, imply a force majeure concept into a commercial contract. So what we've kind of fallen back on and what will be a hotly litigated area will be the concept of impracticability, which is not too far from force majeure. It's just that force majeure has traditionally been reserved for acts of God, tornadoes, hurricanes, things of that nature. But the idea that a superior force has intervened, namely the government, and caused my business to be closed because of a stay-at-home order is in fact causing many parties to visit the notion of impracticability as a means of essentially avoiding a contract term or avoiding the fact of having to keep a promise, whether that be to deliver goods or to pay on time. So impracticability is something that has emerged as a contract, a way of avoiding contracts. Now, as I indicated, this is a hotly debated issue. You're finding legal circles within the United States discussing it and legal circles across borders discussing it. For example, the Hague Convention on Private International Law has essentially developed a pamphlet, and their roundtable and their body of experts have essentially anticipated cross-border disputes arising as a result of COVID-19. Of course, if you have a contract with another country to deliver goods or to pay for goods you've already received, or to continue executing some aspect of a contract. The Hague Convention is already anticipating cross-border disputes and has really developed a method of trying to arbitrate these potential disputes in private forums, kind of like a mediation type of a model for dealing with cross-border disputes. Now, some of the other impacts that we've seen have been moratoriums on residential evictions. Some governors have stepped forward and indicated that landlords no longer, or for a period of time, and it's usually a period of time to end in the foreseeable future, are not able to execute or move forward in court on their rights to evict a tenant who, for example, and I think more predominantly has not paid or will not be able to pay his or her rent. And again, we're talking residential leases, not necessarily commercial leases. I don't know that many governors have stepped in to the commercial domain and indicated to businesses they don't have to pay. But I do know for a fact that there are a lot of governors who have indicated that they don't want landlords running to court and seeking, or filing notices to quit and causing folks to have to leave their residence, because those individuals, again, are not able to work, and it's impracticable under the circumstances to have them evicted when the governor is, in fact, as a major force, has interfered and essentially said, you can't work. So landlords, are having to suffer moratoriums on their right to enforce their leases. There's a lot of movement in the trial courts and even in courts of appeals regarding both cases that were pending and individuals who want to file new suits, whether that be a divorce suit or whether that be a suit to enforce a contract or other types of lawsuits that are happening, including criminal cases. So what the courts have done by and large is essentially yielded to the governors, the executive authority of the governors, and they've actually moved and stepped to comply with those social distancing rules, and to some extent, for maybe a month or more, a lot of courts weren't operating at all because there were court employees who had contracted the virus, and the courts moved quickly not to place anyone at risk. So, but a lot of courts quickly found ways of accommodating the need to move the docket forward and to have people seek redress in the courts. So we've seen the advent of Zoom hearings, and there are other methods for having those public hearings through telecommunication means. But Zoom is one of the more popular methods whereby the court can initiate a call, a conference call with video capabilities, and the litigants can then, through either their mobile technology or through their PCs, access the court proceedings, and the courts have been conducting proceedings in this way. Well, one of the things that's pretty clear at this point is moving forward, there's probably going to be a phased-in return to in-person operations, and to some extent, we may not see in-person operations because of the ongoing need to maintain the safety of all persons involved. So I do believe there'll be, and there are currently, expanded remote hearings so that the courts can conduct business online. The courts have essentially indicated that they want to maintain a minimum of people in the courtroom. So they're limiting access to 10 people or less, and that includes the court staff. So you got the judge, the judge's secretary, you got court reporters, attorneys and their clients, and of course, I believe in every state in the Republic, there's an open meetings requirement or a requirement that the court proceedings be open to the public. So you would ordinarily have not only the litigants and the court staff, you'd also have members of the public who would be present in the courtroom. And obviously, if you're going to limit the courtroom size to 10 people, including staff, that's going to be virtually impossible to do to meet all those requirements simultaneously. So the imposition of social distancing and those practices will continue moving forward. I don't see that the courts laxing standards such that that's going to become a non-issue. That's going to be an issue moving forward, and it's certainly an issue today. There'll be limited in-person courtroom activity altogether, so that only the essential functions that must be done in person will be done in person. And with e-filing, with the uploading of documents to a central server maintained by the court or an entity employed by the court, there's very little that you must do in person. Now, the exception to that obviously are criminal proceedings where you have a respondent or you have a defendant in custody for some reason. Obviously, that's going to be a bigger problem for those cases, but by and large, a lot of the correctional facilities were already having the criminal defendant appear by video conference. So in many cases, they weren't actually physically walking into the courtroom at all, which has presented challenges for counsel who need to communicate with their client, and the client who needs to be able to communicate with their counsel as the proceeding is moving forward. But these pieces were already in place prior to COVID-19. So the category of things that cannot be done remotely, I believe, is becoming narrower and narrower. It's becoming very narrow, so that you can't really find things that cannot be done remotely. Now, there are some exceptions to that, in particular when it comes to trials. A lot of attorneys now are objecting to proceeding via Zoom with trials or any type of proceeding where someone's liberty may be in jeopardy. So typically, prior to a Zoom court hearing, the court will indicate that any party that does not agree with proceeding on Zoom can so make that objection, and if that objection is in fact made, chances are that proceeding will not move forward. A lot of attorneys are not objecting necessarily to having status conferences or pretrial hearings necessarily via Zoom, but anytime I've seen someone talk about trial, or when the court is looking for a date for a trial, without exception, attorneys are objecting to moving forward via Zoom because there are a lot of due process issues involved in that. Number one, if a criminal defendant or respondent is testifying remotely from his or her home or their vehicle or wherever they happen to have access to the internet, you don't know who's in the room. You don't know what information they're reviewing, whether they're reviewing information that might be on the computer screen, if there are individuals in the room who shouldn't be, who are coaching them. So there are all kinds of issues that prevent the litigants from being able to fully assess a person's demeanor and the trustworthiness and so forth, things that you would be able to readily ascertain if the person was in the same room with you, a few feet away from you in the courtroom. And this doesn't just apply to respondents or defendants. It applies to anyone who's offering testimony to the court. If you can't determine or you can't fully assess the surroundings, who's in the room, whether or not they're reading something from a script that's in front of the computer screen or off the computer screen or on their phone, it creates a problem and a challenge for the court. So these are problems moving forward. And again, that's, I think, somewhat a minuscule problem compared to the challenge of being able to select a jury via Zoom. And I don't think any court thus far has been able to come up with a strategy for selecting a jury via Zoom. It's virtually, no pun intended, impossible to do via Zoom. So a person's right to a jury trial, if that is a right afforded in that particular proceeding, and of course the right to a speedy trial if in fact proceedings are being delayed because we can't get agreement moving forward, or if because a person simply objects on due process grounds to having that proceeding via telecommunication means, is going to create problems, obviously, constitutionally for the courts and for individuals moving forward. Now, a lot of courts of appeals have already, kind of foreshadowed, this problem by saying, look, we see no constitutional outrage inherent in having a Zoom hearing or having a trial by Zoom, but that's not stopping attorneys from exercising their right to zealously defend their clients and saying, we're going to object moving forward because I think on due process grounds, my client can't get a fair trial in this environment on Zoom under the circumstances. So these are challenges that the court is trying to overcome. And again, the idea that there's going to be a phased-in return is further complicated by the fact that a lot of state courts are really adhering to Center for Disease Control, CDC guidelines, and trying to adapt their policies accordingly so as to make sure that the cleaning and sanitation of the spaces where folks have to frequent in court proceedings are clean according to certain standards. There's also new standards for screening employees coming into the building and also screening visitors for illness and for protecting vulnerable individuals who have to access the court space. Now, I mentioned earlier about the requirement that hearings be open to the public. A lot of courts are accommodating that by using YouTube A lot of proceedings are being broadcast via YouTube. This is not a bad way of doing it, of meeting that requirement, except for a couple of snags. One, if you have a proceeding, for example, involving minor children, say a child protective proceeding, we have to protect the images of children that are being broadcast into the public domain. So these are challenges that the courts are facing. So some courts are meeting that by allowing parties or counsel for children or any party to a proceeding to file an appropriate objection, and then the court will deal with that accordingly. In other circumstances, the courts are leaving those videos up for a short period of time and then taking them down shortly thereafter, so as to comply with the open hearings requirement, or the public access to open hearings requirement. Some of the other concerns or problems that are emerging is there are certainly new restrictions on legal immigration. There are individuals who have pending applications in U.S. State Department facilities across in other countries that are not able to have those applications processed. So there's some delay because of shortages of staff, and there are other delays because of certain moratoriums that have been issued by the White House as to who and from what countries people are allowed to legally immigrate. So those are some of the challenges happening in the immigration space. The other things that are happening is there's been a deluge of judge-made laws and appeals. So lawyers are filing briefs left, right, and center, objecting to various aspects of, for example, conducting hearings on Zoom, and also there have been objections filed and lawsuits filed against governors on the theory that the governor has overstepped his or her authority by exercising or issuing a blanket stay-home order. So these are type of things that are happening. And again, I mentioned earlier about the breach of contract and practicability concerns that are happening. So a lot of judges are going to have to contend with businesses and litigants indicating or trying to get the court to interpret a contract term in his or her favor or in its favor, so as to excuse a condition. So we can expect a deluge of appeals and lawsuits in that regard. And also, there's a nuanced treatment of criminals. Many of us have seen criminals who, I say criminals because they're being convicted of such, who have been allowed to leave facilities earlier because of the fear that that particular inmate would infect or be infected by other individuals in the detention facility, jail, or prison. So we've seen folks released early on heightened types of tethers and other types of release and bond conditions, so as to protect both the individuals in the facilities and also the staff that work there. So you have that challenge, in addition to the idea that if you have someone, let's say, who's waiting for trial, and if you go back even to March when some of the stay-at-home orders were being issued, they had individuals who were already in custody, juveniles in facilities, individuals in county jails, waiting trial, and again, against the backdrop of they have a right to a speedy trial, and the courts being really unable to function through no fault of their own because of the pandemic. So a lot of courts had to become very creative in terms of how are we going to get these individuals hearings, how are we going to be able to address and balance the various rights associated with a criminal proceeding, so that the people have their right to be protected from someone who's been convicted, but also that the defendant is also afforded the rights due to him or her under the Constitution. Okay, to manage financial crisis, you need an actionable strategy. You need to reduce your exposure to lawsuits and seizures. Second, you need to preserve your credit rating. Third, you need to preserve your future income. And fourth, you need to consider the tax consequences of debt relief and debt settlement. And also, your strategy needs to be able to help you discover whether or not bankruptcy is right for you. Even though bankruptcy will, in many regards, cancel all of your debts, it's not for everyone. Reducing your exposure to lawsuits and seizures. There are three major aspects of this particular leg of the strategy. First, you have to be proactive, and you have to be unafraid to approach your creditors and see if there's anything available that will help you address either a current default or a potential default. Most contracts define a default as a payment that's more than 30 days late or 30 days after the date that it's due pursuant to the contract. Many contracts have grace periods, 5 days, 3 days, where you're not late, sometimes even 15 days. But generally after 30 days, you're considered to be in default. And once you're in default, the creditor then has the right to exercise all of its rights to terminate the contract and sometimes to even accelerate the balance due, so that if you owed $3,000 over a 3-year period of time, now the entire amount is due and owable. And if, God forbid, they take you to court, you may end up having to pay their legal fees. In many contracts, people don't notice it, but they've already conceded the jurisdiction. So you may live in Florida, but the contract requires you to litigate any disputes in, say, Delaware. So if the contract says that and you're in breach or you're in default because you're late paying, you may end up having to answer a lawsuit in another state. Oftentimes people waive their rights to jury trials in these contracts, and they don't notice that. And sometimes the contracts even indicate that in the event of a dispute shall be settled by arbitration. So that's a process that's foreign to most people. Many lawyers have never even had to deal with the American arbitration rules or any other type of commercial arbitration rules that may govern a proceeding pursuant to a contract to which you are found to be in default. So you want to be proactive. You want to communicate with your creditors. You want to make sure that they are availing you, or you're availing yourself of any program that might be enacted, in particular in light of COVID-19, that might give you relief either temporarily or even long-term from the debt that you owe. If you're watching television, of course, you've seen some of the larger mortgage companies are offering many types of rebates and deals. Sometimes they're going to give you a renegotiated rate, which is to say the entire contract might be renegotiated such that your rate is reduced over time. They may put payments on the back end of your loan. But the bottom line is that there are a lot of different programs that many lenders are putting in place so that people do not find themselves in breach just because of impracticability, meaning the governor has essentially closed your state down and you're not able to go to work, or your line of work is considered to be non-essential, or you're laid off, God forbid, and now you're having to deal with trying to keep your family afloat with little or no income coming in. So many businesses don't want to have to find their customers, especially large numbers of customers, in default because of no fault of their own, because folks are trying to deal with the pandemic. So you have to be proactive. You have to reach out to your creditors and find out if the creditor has a self-imposed moratorium on fees, or if the governor or some other entity has stepped in and indicated that fees shall not be collected during a certain period of time. I would recommend, secondly, that you draft hardship letters. In particular, hardships are typically things like it could be my job was eliminated because my company went under due to the COVID-19 pandemic. It could be I'm caring for an elderly family member who has extensive needs that are not covered by insurance, and I'm having to go out of pocket or go into savings in order to care for this individual. These are the type of things that could be hardships. Special needs children that have needs that require you to, not be or make it difficult for you to be at work because you're having to go to the school or go to meet with healthcare professionals or mental health professionals to help deal with and treat that special needs child. These are the type of things that amount to hardships. Now, the hardships typically are events that you can substantiate through documentation. You're going to have doctor's appointments. You're going to have psychiatric diagnoses and things like that, or reports generated by mental health professionals as to the extensive needs of these individuals. Now, you don't necessarily have to give anyone a copy of someone's full-blown diagnostic report, but you can get letters from doctors, letters from healthcare professionals that summarize what the individual is suffering and what type of care needs an individual has. And again, these things can buttress your discussion or your argument for why you should be given consideration, or why you should be allowed, or why the company should be more inclined to compromise the ultimate amount of debt that you have in light of hardships that you have. But if you're experiencing hardships, you want to start documenting those events, emails, text messages, whatever you have that can substantiate your claim if you need to make it that you're struggling financially. Consider, thirdly, walkaway agreements. Walkaway agreements are essentially agreements that allow you and a creditor to walk away without any additional adverse impact to your credit rating, and certainly any legal action whatsoever aimed at you. More commonly than not, these type of agreements are seen in the real estate industry. There are things known as deeds in lieu of foreclosure, where essentially you negotiate with the mortgage company or companies, if there's more than one, an arrangement whereby you essentially surrender the premises in exchange for a consideration that you no longer owe any debt on the mortgage. So your mortgage is essentially canceled. You surrender the premises in exchange for an act of forbearance, or an agreement for forbearance agreement, which is basically something stating that the mortgage company is not going to come after you for the note. As you know, when you purchase real estate, there are two essential documents that secure that purchase. One is your mortgage, which is the money you borrowed from the bank, and second is the right for the holder of the mortgage to foreclose on that property should you come in default under the terms of the mortgage itself. So under a forbearance agreement and a deed in lieu of foreclosure, you would essentially enter into an agreement with the mortgage company, and obviously it needs to be in writing, wherein you agree to surrender the premises on a date certain under certain circumstances, meaning it will be broom swept clean, what have you. No damage to the property other than normal wear and tear. And in exchange, they promise they will not pursue any legal action against you. Now, this is an extreme circumstance. Most people do not or are not able to walk away from their homes. But there are circumstances with not just real estate, but with other property that's secured as collateral for a loan, whereby you can enter into a walkaway agreement with the holder of that note. Now, in looking at whether or not that's something you want to do, I would strongly urge everyone who's in need of or having concern about meeting their financial responsibilities under the COVID-19 era to visit the National Consumer Law Center. National Consumer Law Center, they produce a book called Surviving Debt. It's a 288-page document that covers pretty much every aspect of consumer debt. It will help you assess whether or not you want to surrender property, and if so, under what circumstances. Now, under the COVID-19 emergency, the National Consumer Law Center has made that e-book available for free. Ordinarily, you would have to buy a subscription to their website to be able to access that book, and it's an extremely well thought out and well resourced pamphlet or book that will help you determine whether or not you want to walk away. And it also has all kinds of helpful guidance about pretty much every aspect of debt relief and dealing with creditors and negotiating settlements and things of that nature. So I would strongly urge anyone in need to go to the National Consumer Law Center's website and access that valuable resource while it's still free to do so. Preserving your credit rating. Now, to the extent that you want or need to preserve your hard-earned credit rating, there's some things you need to do and be aware of. But first, understanding what credit scores are and how they are derived by the three credit reporting agencies. Credit scores are, of course, based on the standard FICO score. Typically, they range from 300 to 850. Now, some industry-specific credit scores range from 250 to 900. But nevertheless, these ratings are going to make or break you sometimes when you apply for jobs, but most certainly when you apply for credit. Every entity under the sun who is in a position to grant or loan you money is going to want to know what your credit scores are, and they're going to want to see your credit report. And I trust everyone knows that annually you're entitled to one free credit report a year. So if you haven't already done so, you want to make sure you request a copy of your credit report, because you're entitled to one free credit report a year. and that'll help you assess where you are and what your scores are. So to give an example, let's assume that you have a $200,000 principal and a 30-year fixed rate on your home mortgage. The importance of credit scores is illustrated as follows. If, for example, on that $200,000 loan, 30-year fixed, your credit rating was between 760 and 850, your interest rate is going to be 3.199%, and your monthly payment is going to be $865 a month. Now, if you skip ahead to pretty much the bottom of the barrel, for the most part, most people, who have really poor credit are probably going to be at 620 or somewhere between 620 and 639. If that's in fact your score, then your interest rate on that $200,000 loan, 30-year fixed, is going to be 4.788%, which translates out to about $1,048 a month. So there's a substantial difference between what you pay with a 3.1% interest rate and a 760 credit score versus a 620 credit score, and paying almost 5% interest a month on that same loan. Now, what are the factors that go into determining your credit score? What do the credit rating companies or the credit reporting agencies use to determine what your credit score is going to be or is? There are 5 particular things that they look at, 5 factors. First, 35% of your score is based on your payment history. So, have you made payments on time? Have you paid as agreed? 35% of your score is going to be determined by those type of factors. Another 30% is going to be based on your current debts. So if you have a high income to debt ratio, meaning pretty much you're living hand to mouth, and almost every penny you get on a bi-weekly or monthly basis by way of your income is going to pay creditors, that's going to affect your score up to 30% of the 5 factors. Another 15% is determined by your history. Again, that's not too different from the first factor, but credit histories can go back quite some time, as opposed to the most recent 6 months, which might be very good. They might go back up to 7 years, looking at how well you paid on time, or have there been any issues with regard to your credit, your ability to pay back your debts on time. Another 10% is allotted to new credit applications. So if you're constantly asking or applying for credit online, you go into a mall and they say, well, if you apply for credit here, and you're approved, this purchase is not going to cost you very much. If you continue to do that, those are going to continue to show up on your credit report. And to the extent that it's adverse to you, that affects you by 10% of the total score that the credit rating agencies look at. Another 10% is derived or looked at based on the type of credit you have. So if you have a lot of credit card debt, that's viewed in one particular vein. If, for example, your debt is long-term, you have student loans and you have mortgages and not a whole lot of short-term debt, those things are looked at differently. But to the extent that they matter at all, they only matter about 10% of your score. The next thing we need to talk about is preserving your future income. Now, preserving your future income has 3 aspects to it. The first is doing a deep dive. The second is investing in what matters. And the third is taking immediate action. Now, doing a deep dive starts with tracking every penny that you're spending. You want to know all of your income is going. So every dime that comes into your home, into your bank account, you want to be able to account for where that is in fact going. Second, having done that, you want to develop a budget to make sure you're only paying for or planning to pay for the essentials. Certainly you want to carve out car maintenance and things like that are foreseeable, but may not occur every month. But if you have a small amount of your budget carved out for that, you've made an allowance for that just in case, or to say when your car eventually requires maintenance, whether that be a routine oil change or a new tire. Again, you want to prioritize your debt. Now, prioritizing your debt is something I'll address shortly when I talk about the 3 tiers of debt. Some debt is obviously more crucial or important than others. And I think it's important that you prioritize your debt to know which debt you need to pay immediately and which debt may be able to wait a little long. Connected to the 3 tiers is knowing the difference between good debt versus bad debt. So again, some debt is good to have. For example, mortgage debt is typically good to have because investing in something that hopefully will appreciate over time, and something that is an essential, namely your home. So that's generally considered a good debt to have. The other good thing about mortgage debt is oftentimes if hopefully your home is appreciating and is developing equity, you could eventually perhaps refinance that loan to receive a better return on your investment, and perhaps take that equity and invest it in something else, maybe a retirement fund or a education plan for children. So home can be an investment. It's not necessarily a liability as a car is. A car is more of a liability in that the minute you drive it off the lot, it's worth less than it was when you purchased it. Homes typically do appreciate. They do tend to gain in value. This is considered a good debt. Student loans are typical, and they can be good investments for those who are entering fields where a college degree may be necessary. And so it's not just college where people are, sometimes trade schools. People incur debt from trade schools if they find necessary to do so in order to complete that course of education. But investing in your education is typically considered a good debt. And the other good thing about student loans is that because there's a lot of government oversight on student loans, there are a lot of ways that you can negotiate with the public loan companies that are loaning money to people pursuing their education. And typically a student loan, it is a public student loan, doesn't become delinquent until you've missed nine payments. So, but there are a number of different ways that you can defer the loan in their circumstances in which you may be able to get forbearance from a student loan. But these are things that require you to really talk and work with the lender to be able to discover what programs you're eligible to be able to perhaps defer a part of your student loan, if not completely, seek forbearance for a portion of it. And of course, with student loans, your interest rates are typically very low. And again, I'm referring to public loans, not private student loans. The interest rates are usually pretty low. So the return on that investment in terms of your ability to acquire a profession or a skill, whether that's to a trade school or a college, may far offset in the long run the investment you're making into those loans. So this, generally speaking, those are good debts versus bad debts. But in terms of prioritizing your debts, there are 3 tiers. Again, not all debts are equal. Some debts you want to pay right away, and some debts you may be able to, kick down the road a little bit, either through negotiating with a creditor or through other means. For example, with utility bills, where you may be able to enter into an installment agreement with the entity that is responsible for that utility bill. But just to summarize, Tier 1 debts are debts that have to do with the potential deprivation of your liberty. In other words, if the court has issued an order for you to pay a particular debt, and I don't care if it's a traffic ticket, a speeding ticket, or a jaywalking ticket, if a court has issued an order for you to pay a fine, you want to make sure you pay that right away. And contrary to popular belief, there are debtor prisons in the United States, and a debtor prison is seen as follows. You have an order to pay a debt, whether that be a fine or what have you, but the court has issued an order for you to pay a debt. That might be an order for you to pay alimony. It might be an order for you to pay a judgment in a civil suit or a small claims case that you lost, and there's an order for you to pay the plaintiff or the other party a fee. Well, let's say you decide, well, I'm not going to pay it, I don't have it, or I'm on welfare or what have you, I don't have to pay it. Well, that's fine and dandy up until the point where the judge commands you to appear in front of him or her and explain why you should not be held in contempt of court for not complying with the order to pay the other party pursuant to the judgment. Okay, let's say you receive notice to appear at a hearing to answer the court's question as to why you shouldn't be held in contempt. You don't go to that. Well, the next thing that's going to happen is the court's going to issue a bench warrant, which is essentially a warrant for your arrest. At that point, you're going to be arrested as if you committed a real crime, and you're going to sit in jail until you post bond, and usually that bond is the amount of the debt you owe. So to the extent you're able to pay the bond, you're able to get out. But to the extent that you're confined or detained at all because of a debt, you're in a debtor's prison. So you want to make sure that you pay as quickly as possible any debt that's required to be paid pursuant to a court order. Again, these are tier 1 debts, and this debt supersedes any other debt you're going to have to pay, because it's very unlikely that the mortgage company is going to have you arrested if you don't pay your mortgage on time. If you don't pay your car note, the worst that could happen is they repossess your vehicle, but you're not going to end up in a cage. So you want to make sure that if it's a court order that you pay something, that you pay that. That's a tier 1 debt. Similar to that are criminal justice debt. So if you've been convicted of something and you've been ordered to pay restitution to the victims and you don't pay it, you're going to find a similar circumstance wherein you're answering a show cause order from a judge, and if you don't respond to that to the court's satisfaction, you may find yourself in contempt of court there as well. And then it's the age-old chicken and the egg problem. Well, if I'm in jail, how can I work? And if I can't work, how can I pay? Well, the answer to that question is you should have thought about that before you ignore the court order. So you don't ever want to be in a situation where you're ignoring a tier 1 debt. Automobile loans and leases are also considered tier 1 debts. Yes, you won't get incarcerated because you don't pay your car note on time, but if it's possible for the company who holds the paper on your vehicle to seize that vehicle without breaching the peace, meaning you park it out in front of your house, you come out in the morning and it's gone, you're now without a vehicle, you're now without a means to get back and forth to work, you're now without a means to to care for children if you have to drive them to school or what have you. So it is in many states where we don't have public transportation a necessity, and that's why it's considered a tier 1 debt, because if you don't attend to it properly, your vehicle's going to be taken and you're going to be in a much worse shape than you were before, because now not only are you going to be on the hook for the amount of your loan, which of course far exceeds, I'm sure, the value of your vehicle at that point, you're going to have to deal with the fact that the company who sees your vehicle is now going to place your vehicle in storage. There's storage costs. They're going to have an auction and a sale. There's costs associated with that. And of course, there'll be legal fees associated with that. And if you look at your contract in the fine print, you'll find that in the event of legal action, you have essentially agreed to pay the reasonable fees of their attorneys. And I guarantee you almost every fee that they assess is probably going to be deemed by the court to be reasonable. So you're going to end up paying their lawyers, you're going to end up paying storage fees and the cost of auctions and so forth. And of course, anything that exceeds the amount you owe won't be assessed against you, but more often than not, there's going to be a deficiency after they sell your vehicle, because people who go to auctions go there to buy at a bargain. So if they sell your car, that's worth $5,000 for $500, there's a $4,500 deficit there, plus the storage fees, plus the legal fees, plus the fees associated with the auction or the sale itself. So failure to pay an automobile lease or a note on a vehicle is, those are considered tier 1 debts as well. Utility bills are considered tier 1 debts because obviously in the wintertime, for example, in certain states, not having utilities is a death sentence. But the good news is that most states have statutes that prevent the utility companies from terminating service such that it might place someone's life at risk. And the other good news is that almost every state has, or every utility entity has a mechanism in place to negotiate with consumers so that they can, either through an installment or some kind of debt forbearance or something, maintain or keep their utilities in place. But bad news doesn't get better with time. Unlike certain types of wine, what will happen is that if you don't stay on top of these things and you don't communicate with creditors, you don't communicate with the utility authorities, you're going to find yourself in shut-off circumstances, and you're going to need to deal with that, and the longer you wait, sometimes the harder it is to overcome it. So but because of the potential threat to your life or limb, obviously if you don't have water, you can't live. If you don't have heat and electricity, it's almost impossible to be able to carry on a normal life. These are considered tier 1 debts as well. And finally, child support. Child support is a tier 1 debt, in large part because it is the right of a child to receive these payments, and child support belongs to the child, which is why parents aren't able to waive child support for a child unless the court determines the child support is not necessary for a variety of different reasons. But if child support has been ordered, it's been deemed necessary, and it is a right of a child, and if you don't pay it, you can find yourself in a cage. You know, it is akin to court judgment debt in that there's an order for you to pay. If you don't pay, a judge is going to issue an order for you to appear at a show cause hearing to show cause why you should not be put in a cage for failing to comply with the court's order. So child support is Tier 1 debt, both because of the necessity of caring for kids and the importance that the government assesses to that, and also because it has been ordered by a court of competent jurisdiction. So you do need to make sure that these debts, above all, are paid before you consider any other debts when you're dealing with limited income. Tier 2 debts are home mortgage delinquencies. So obviously, you know, your home is very important, so you don't want to lose your home because you're not paying your mortgage on time. So obviously that's the second tier of importance for the category of debts that you need to worry about. Real estate taxes are really key, because a lot of people, even if they own their own home outright, can lose their home for not paying city taxes or you know, any tax that's been assessed by an authority of the government on your property. If you don't pay it, they can foreclose on your home, much like a mortgage company could, and you can lose your home that way. So you have to treat those with equal degree of seriousness as you would your mortgage if you have one. Student loans are considered Tier 2 debts as well, and the reason why they're considered Tier 2 debts, even though there are all kinds of deferments and there are all kinds of forbearance arrangements you might be able to qualify for a student loan, and even though they typically are not delinquent until you've missed 9 months or so of payments, they're very hard to discharge in bankruptcy, if not impossible, and because of that, you're going to be stuck with them until they're paid. Now, obviously, the good news is that there are a lot of things you can do to kind of kick the can down the road, so you're not worried about the student loan right away. But because of the fact that it is a debt that almost cannot be erased or forgiven in its entirety, it is also considered a Tier 2 debt. And the last of the Tier 2 debts that I want to talk about are taxes and amounts owed to the IRS. Again, IRS debts are almost impossible to erase. The good news is that many times the IRS will enter into an offer and compromise with the taxpayer so that they pay a substantially lower amount than the amount due on their taxes. There might be a civil penalty associated with that, but they'll typically roll the civil penalty into an installment plan that you can pay on a compromised amount. So they'll work with you as long as you don't have a long history of evading or history of evading altogether. They'll work with you so that you can try to get that debt into manageable chunks. But if you ignore it, it will not go away. And if you find yourself in bankruptcy court, you'll find that the IRS is sitting there at the table as a creditor demanding payment, and you won't be able to discharge that debt except for very limited circumstances. And typically, it's probably fair to say you're not going to get rid of that IRS debt. So that's why it's considered a Tier 2 debt as well. Your Tier 3 debts, again, these are not that they're not important, not that you should not pay them, but in order of importance, these are the third tier of debts that you need to worry about. These are medical bills, credit card debt, debts owed to friends and family, private student loans as opposed to public student loans, deficiencies on repossessed vehicles. Now, I talked about in Tier 2, your vehicle is a priority, but God forbid if it has been repossessed, now you get what's known as a deficiency judgment. Almost guaranteed you have a deficiency, meaning not only did you lose your vehicle, now you still have to pay the company that held the paper on it, and that paper, of course, has probably been sold to someone else. So whoever the holder of that paper is now has a judgment for the deficiency, which is the difference between what you owed and what they were able to get in the sale of your vehicle, plus legal fees that are considered reasonable by the court. So these are debts that will emerge and arise if your vehicle is repossessed. But nevertheless, it is a third tier debt, which is in order of importance and magnitude below Tier 1 and Tier 2 debts. Charge accounts and debt secured by small appliances. or say household appliances, refrigerators, microwaves. Sometimes people go and they buy small appliances for their home on credit. Sometimes that item is collateral for, they'll make you sign what's called a security agreement, basically letting them repossess that item if in fact you are in default. And again, default is just 30 days or more late on your obligation to pay. But oftentimes they won't. They won't actually secure that item by saying, oh, if you don't pay, we're going to come and get it. So you may be able to keep that item if they don't file what's known as a security agreement with the state. But nevertheless, it is a debt that has to be dealt with, and but it's in terms of importance beneath a Tier 1 or a Tier 2 debt. What are the tax consequences of debt forgiveness? As you look at developing a strategy to address your debt in the COVID-19 era, you really have to consider what are the tax consequences of debt forgiveness to the extent that debt is forgiven. Earlier I talked about the fact that many companies in this COVID-19 era are offering forbearance of either a current month or maybe a couple of months of debt or payments due under a particular contract. And in some cases, the interest rate has been reduced, and that may not have any tax consequences, but the impact of that has yet to be seen in terms of whether or not you're going to get issued what's called a 1099-C. Now, typically, prior to the COVID-19 era problems, what we were seeing is that if a credit card company, for example, forgave, let's say you had a $3,000 loan on a credit card and they forgave it, because you asked them to forgive it, and there was some negotiation, and then there was a hardship letter proffer, and then it was accepted. It's okay, we're going to go ahead and forgive, or also known as write off your debt. Well, the thing that would happen is you think, oh, I walked away from that debt and I'm free and clear. That's true up until you receive what's called a 1099-C in the mail, which is essentially a statement by the credit card company that you enjoyed $3,000 in ordinary income to the extent of debt forgiveness. Now, what that means is that you have to now report that on your income tax return in the year that you received it as ordinary income. So this can be a problem for debts that are forgiven. So there may be tax consequences if you do have debt forgiven, and you have to be aware of that. You can certainly discuss that with the creditor if in fact you enter into a discussion about forbearance of a debt or forgiveness of a debt. But you do need to be aware of that. Now, there are two exceptions to that. One is on your primary residence. So if through 2016 there was a cancellation of your mortgage, and let's say up to $2 million, you can seek this exception. There was cancellation of your mortgage, and the indebtedness had to do with purchase or improvement of your home. Then, if that debt is forgiven up to $2 million, you can, you're not going to have a tax consequence as a result of that. But again, that's only if the loan was to improve or to purchase your primary home. This is not for commercial real estate. The second exception is the IRS's insolvency test. Insolvency is defined as a state where your liabilities exceed your assets. So you're making $2,000 a month, but your bills are $2,500 a month. Well, by definition, you're insolvent. There's more money going out than coming in. Those are the two exceptions to the rule of debt forgiveness, essentially amounting to the realization of ordinary income in the year it was forgiven. So those are the consequences essentially of debt forgiveness. So you have to be cognizant of that if in fact debt is being forgiven. Now, the other aspects of taxation that are useful, in particular in this era, is that on March 27th, the President signed into law the Coronavirus Aid, Relief, and Economic Security Act, sometimes referred to as CARES. That particular act carved out some helpful provisions both for individuals and for businesses. For individuals, primarily what it does is it allows you to borrow from your retirement account, IRA, SEP, 401k, without having to suffer the tax consequences. Now, ordinarily, if you have money in a retirement account and you take that money out before what's known as the distribution phase, when you're 62 and a half years old or 65 and you retire, if you take that, any money you've contributed tax-free to a retirement plan prior to the distribution phase, you're going to suffer a penalty for that, meaning you've experienced ordinary income. In addition to that, the plan that manages your particular retirement fund is going to charge you, an interest penalty of usually 10%. So you're going to have a huge hit on the money coming out, and it's going to get taxed as ordinary income when you file your income taxes. Now, the CARES Act essentially carved out space for you to be able to take up to $100,000 from your retirement account without having to suffer that penalty at all. So it's a great opportunity for people who may need to borrow a little bit from their retirement plans in order to be able to, to get over the hump while they're waiting to go back to work or waiting to be able to weather a storm that was brought on during this era. So that's primarily, the carve out for individuals from the CARES Act. Now, for businesses, there are a number of different things that were carved out for businesses under the CARES Act. Number one, there's an employee retention credit. So if you keep employees when other folks are laying people off, there's a credit assessed or that you can take advantage of at the end of that particular tax year that will hopefully help the business moving forward. There's deferred employee payroll taxes, so you can defer the payroll taxes you have to pay on behalf of your employees. There's changes to mandatory paid leave. So there's things that you can do with regard to mandatory paid leave that you may have to pay, whether that be family medical leave or some other mandatory leave that you have to afford to your employees. There are changes to the treatment of those payments made under those circumstances. There's also changes to the treatment of net operating losses. So you're able to deal differently with losses to the business than you would have been able to do prior to the CARES Act. And of course, finally, there are government loans to businesses. I've had a couple of clients who've taken advantage of these loans. They're low interest loans that you pay back over time, and they can be a helpful infusion of money to, in particular, a small business that's trying to stay open in the midst of the COVID-19 era pandemic. I want to talk now about some of the disadvantages of bankruptcy. As I indicated, the last step of an actionable strategy for surviving financial crisis is making sure that you're determining whether or not you even need to file bankruptcy in the first place. The starting point for that, to me, is to really talk about what are the disadvantages of bankruptcy. The first disadvantage is that every aspect of your financial affairs will be scrutinized. So if for some reason you have irregularities in your banking, you have irregularities in your tax filings, chances are those irregularities are going to be discovered during your bankruptcy, and if they are discovered, you can be subjected to criminal penalties or civil fines as a result of those irregularities. So every aspect of your financial dealings for many years past are potentially going to be subject to scrutiny by government or people who are working on behalf of the government. Typically in bankruptcy court, you're dealing with the bankruptcy trustee. You rarely see a bankruptcy judge unless there's litigation in your bankruptcy, but you will definitely see the bankruptcy trustee. The trustee is essentially an attorney. Sometimes a trustee is a law firm that's been appointed on behalf of the court to ensure that the bankruptcy estate, and the estate is everything that you own, including your debts. The bankruptcy estate is administered properly so that you are treated fairly and that creditors are treated fairly. And put it another way, to make sure that you're not keeping things that rightly should be sold for the benefit of creditors. So the bankruptcy trustee is responsible for that, and to make sure that the rules of the bankruptcy court are properly executed. So if there's anything going on in your finances that's troubling, chances are it's going to be discovered. I've told people many times, don't try to get cute and not include an asset. The stories abound of people showing up at bankruptcy hearings. They call them 341 hearings. That's when you usually your first foray into the court, and you're there and you're meeting with the bankruptcy trustee. It's called a 341 meeting of creditors, and sometimes your creditors are also there, and sometimes they'll come to the table, represented by their attorneys. And let's say, for example, you're wearing a very expensive ring that somehow or another did not find its way on your schedules. Well, you might be questioned about where that ring comes from and why is it not on your schedules. Again, any aspect of your financial dealings and what you own and who you owe, who you paid off, a year or 6 months prior to filing, could be something that would be asked of you in a bankruptcy. And you're not able to avail yourself of the advice of counsel defense, meaning my lawyer told me to do this, to manage my affairs this way. the advice of accountant defense. My accountant told me to manage my affairs that way. You're not going to be able to avail yourself of those offenses in bankruptcy. You know, anything that you've done with regard to your finances or your debts is going to be potentially scrutinized, and again, there are penalties if irregularities are discovered. Second, a bankruptcy can be reported on your credit report for up to 10 years. That's usually a Chapter 7. A Chapter 13 is usually removed after 7 years. So, you know, for many years after you receive a discharge, you're still going to have that bankruptcy looming on your credit report. So, you know, you may have emerged from bankruptcy, you know, you're a much better financial planner, you got a new job, things are different for you, and then 4 or 5 years into your successful reemergence from bankruptcy, you're still having to answer questions as to why you filed bankruptcy, and then kind of having that stigma of being a bad credit risk on you. So you have to know going in that you know, mark, if you will, on your credit is going to remain there for, you know, up to 10 years under Chapter 7 and about 7 years after reemergence from a Chapter 13. So these are that is a concern as well. Avoiding bankruptcy. In this particular session, I want to talk about strategies for getting your debt back under control. Now, avoiding bankruptcy has 4 different steps, or 4 precisely, that I want to talk about. But the other aspects of getting your debt back under control and avoiding bankruptcy have to do with debts you may not owe, or certain debts that you think you owe, but actually legally you may not owe those debts. I'll talk about that in part 2. Also, the consequences of ignoring your debt. What could happen? What could go wrong if you actually don't pay them and just ignore them? And finally, are you even a candidate for bankruptcy? Now, there are certain tests that you have to take and apply to your circumstances. One of those is called a means test to determine, for example, if you're a candidate for Chapter 7. In other words, if you make too much money, you may not be able to apply for Chapter 7 relief. If your plan that you have is not feasible, meaning, you know, given the money you have and given what you're able to pay, your plan overall doesn't make any sense mathematically, then you probably won't be able to apply for a 13 either. So, and again, most people will be able to seek relief from one of those 2 provisions of the bankruptcy code, but you do need to make sure that you are seeking the right chapter of the code, whether that be a 7 or a 13. And again, and that's going to be determined in large part by how you come out on the other side of the various tests that you will have to take in order to see if you're eligible. But again, I'll cover those aspects in the next video. Now, in terms of getting your debt back under control, there are 5 strategies to that. And the first one is assuming that none of your debts are in default, none of your loans have actually gone into default, meaning you still have the ability, you have a window of time, you have an opportunity to get in there and negotiate with your creditor. Then you have to think about reducing your monthly debt overall so that you can make certain payments that make sense. Strategy number 2 for avoiding bankruptcy. I mentioned this earlier, but negotiating with your creditors is crucial at every stage of the process. Remaining in communication with your creditors. I mentioned earlier about documenting everything. Sometimes you'll find yourself talking to people in a customer service desk. Many of the larger companies don't just have customer service centers in one state. They may be in several states. Sometimes you'll find yourself talking to someone in the Philippines or in India, and you may find yourself talking to a different customer service center every time you contact someone about your debt, and rarely will you talk to the person who actually has the power to assist you. But you have to be persistent in talking to creditors, and you need to document with whom you speak. So if you talk to a customer service rep, get their number, their name, and their location so you can document your efforts to stay on top of your debt. Because what you'll find is you'll spend an hour trying to get through to someone and finally talk to a customer service rep and possibly be disconnected. And of course, you think you might have gotten somewhere. They basically did your call to talk to a manager,
Next thing you know, you're talking to a manager, possibly in a different state. You think things are resolved to a certain extent that day, only to return to the same issue tomorrow, contact the same number, and you're talking to someone entirely different. So it's important to document your efforts with the people with whom you speak. If you're able to obtain fax numbers, even though we're living in an email age, you want to do that so that you can fax documents summarizing or memorializing conversations and understandings that you've reached with, say, managers at a particular company. Generally, the people who answer the phone are not empowered to assist you. They're only empowered to escalate your call and to maybe document your concerns in a computer. I would also mention, most parenthetically, that if you're considering bankruptcy, do not mention that while you're talking to creditors. And the reason why you don't want to do that is because oftentimes you'll find things that you communicated to a customer service rep on a call intended to negotiate or to explain a circumstance. You'll find those conversations emerge in your credit report. So if you happen to say, well, if you don't work with me, I'm going to file bankruptcy, and you're not actually going to file bankruptcy, and again, until you actually file, you haven't, you might find that conversation in your credit report, customer says or indicates that they plan to file bankruptcy. Well, if it turns out you don't, then and you get yourself back together a couple of months later, and you apply for credit, that comment could be in your credit report for 7 years. So you don't want to ever threaten anyone with bankruptcy. If you intend to file after you've done the proper analysis and you determine it's what you need to do in order to, get a fresh start or to get back on, to financial health, then you just do it. Don't ever threaten anyone with filing bankruptcy, because it's generally not helpful to do so. But it is helpful to communicate and be patient with creditors, because you have to remember, to that person who's answering the phone, you're just the person on the computer screen, or someone who has an account number. They don't know your personal circumstances, and they may not be empowered to help you, even if you spend hours explaining it to them. But you do need to be patient. You mostly certainly need to be persistent and document what your efforts are with regard to communicating with creditors. As I've indicated, many entities, many creditors, many large businesses now are offering all kinds of forbearance and all kinds of workout plans, and they will work with you to negotiate with you, because we're not talking about, an episodic situation, even on the scale of the mortgage crisis in 2008. We're talking about something that has impacted the entire planet. So, so the scope, is much greater, and the impact is magnified in degrees of magnitude. So no business wants to see customers in droves leaving or not returning because they didn't feel that they were being treated fairly. So companies, while they're not going to forgive everything, are doing what they can in many respects to try to work with people. So you need to take full advantage of that and talk to your creditors, about what's happening, and hopefully take advantage of things that they're offering voluntarily or sometimes involuntarily to assist consumers. The third thing in strategy number 2 in avoiding bankruptcy and preparing yourself for the process, if need be, is avoiding scammers. There are a lot of people who take advantage of consumers, and I suspect this COVID-19 era is not going to be an exception. I think there'll probably be people who will come out of the woodwork to take advantage of consumers who are looking for relief or who are looking for answers. Part of the reason I'm doing this video is to hopefully direct people in towards things that are credible and things that make sense, but most certainly away from things that don't, and that simply don't work. People who call themselves credit counselors or consumer debt relief specialists, many of these people are sovereign citizens or people who don't know anything about the law or personal finance, and you're going to get nothing but a lot of trouble, wrath, acrimony, wailing, and gnashing of teeth. I've had people contact me in the last couple of days saying, a company promised to make my debts go away, essentially, or negotiate with my creditors. I paid them a bunch of money, and my creditors are still calling me as if nothing's happening or no one's working on my behalf. What should I do? And the first thing I told that person to do was to contact the State Attorney General's Consumer Protection Division and report that company, because no one who tells you not to pay your debts should be believed or taken seriously. You can most certainly, as I've indicated, in some cases find yourself in a cage at the order of a judge because you're ignoring court orders or otherwise breaking the law and not paying your debt. So anyone who tells you not to pay your debt is someone you should avoid. Other people to avoid are payday lenders. Many people take advantage of payday lending. A lot of folks are struggling, and they tend to live paycheck to paycheck, and sometimes an unforeseeable event happens. Someone gets sick, or a foreseeable event happens, their car breaks down, and they end up, needing a few bucks, so they go to the payday lender. Well, the problem with that, obviously, and most people who do it know it, but they can't seem to stop themselves, is that you end up paying, 400 sometimes % interest on money that belongs to you. So you certainly want to avoid payday lenders. You want to avoid anyone who's promising to renegotiate your public student loan, not a private student loan, a public student loan that I've discussed earlier. Essentially money that's loaned to people who are pursuing higher education, and is essentially governed or regulated by the U.S. government. Those loans have all type of mechanisms built in. You're not late until usually you've missed 9 months of payments, and there are all kinds of deferments and forbearance mechanisms built into those loans that will allow you to be able to weather a storm, a short financial shortfall, or even this pandemic if necessary. And you don't need any third party to intervene and do what you can do for yourself for free. So there are folks out there who will promise you the moon. Oh, I'll go in and renegotiate this and consolidate that. But the fact of the matter is, there's nothing these folks can do for you at a cost that you can't do for yourself for absolutely free. So anyone who's promising to consolidate your loan for you for a cost, or negotiate a better rate for your student loan at a cost, any of these type of things needs to be avoided, like no pun intended, the plague. So do not deal with any of those type of things. There are a lot of reverse mortgage scams that you want to avoid. A few minutes of internet research could probably save you a lot of wailing and gnashing of teeth. So there are a lot of different scams that are out there, but most of the people who are promising to do for you what you could do for yourself have neither the credentials nor the expertise nor the pure heart necessary to be able to help you deal with that particular crisis. Most of the things that these people promise to be able to do for you, trust me when I tell you, you can do yourself. You just have to be persistent, you have to document, and you have to be patient. Strategy 3 for avoiding bankruptcy: consumer credit counseling. Now, in strategy 2, I talk a little bit about scammers, people who promise to come in and help you renegotiate loans. In some cases, they promise that they will make these loans go away, or in some cases, they'll even tell you not to pay your loans. Don't worry about it, we'll take care of it. As I indicated, many of these people are, borderline or questionable sanity, and most certainly are ethically challenged. So you must avoid these people and not accept or listen to anyone who tells you you don't have to pay your debts back. But consumer credit counseling, on the other hand, sometimes they're known as CCCS, is something that might be useful to you. And this is the third strategy for avoiding bankruptcy. You want to look into this. Now, my suggestion is that you only plan to patronize or seek information from consumer credit counseling agencies that are nonprofit, meaning they're not into this to get rich. Their goal and their primary aim is charitable, and they're trying to help people find actionable strategies, much like this video, to address a financial challenge that you're having. So these companies can be useful, and sometimes they'll sit down with you, if not every time, sit down with you and really do a deep dive, looking at your finances, looking at what you can afford, and helping and assisting you in making recommendations for trimming some fat off of maybe your expenditures. They can help you, weather or navigate through the different tiers of debt. Telling you what debt you really need to make sure you make a priority and pay those first. Give you some strategies and ideas about stretching, dollars over a short period of time if you expect to be back on your feet fairly shortly. The other thing they can do in some cases is they can help you carve out a plan to pay back your creditors, much like a Chapter 13 would do. Now, Chapter 13 is Chapter 13 of the U.S. Bankruptcy Code, and essentially is a plan whereby you pay pennies on the dollar on the debt you owe over a period of time. Now, I say pennies on the dollar, not to necessarily minimize the fact that you're paying a lot of money every month under a Chapter 13 plan, but it's much less than you actually owe generally. Sometimes it's just pennies on the dollar for certain types of unsecured debt. But a reputable consumer credit counseling service, again, they're usually nonprofits, the ones that are best, are going to help you carve out something similar to a Chapter 13 without having to go through the Chapter 13 bankruptcy process. So they can help you work out plans with your creditors, to compromise on it, and sometimes with minimal impact or detrimental effect on your credit report. So this is strategy 3. If you've done strategies 1 and 2, and you're and either of those helped, or you want to use them in combination, you want to check out Consumer Credit Counseling Services. Now let's talk more about some of the common forms of bankruptcy. Essentially, for the purposes of this video series, I'm only talking about Chapters 7 and 13 of the Bankruptcy Code, but the Coronavirus Aid, Relief, and Economic Securities Act, which President Trump signed on March 27th of this year, made some substantial changes to the Bankruptcy Code. And again, that act is sometimes referred to as the CARES Act. It made some substantial changes to the Bankruptcy Code. The first thing it did is it amended Chapter 11 of the Bankruptcy Code in such a way that it streamlines the reorganization process. So Chapter 11, which I'm not covering, is really kind of, they call it debtor in possession bankruptcy. So if a business is going to, the business owner is going to remain in possession of the business through reorganization of their debts, then that's a Chapter 11, which I'm not covering. But the CARES Act does amend Chapter 11, and it carved out some important pieces for people who are in Chapter 11 bankruptcy. So just wanted to mention that one. But in terms of consumer bankruptcies, Chapter 7 and Chapter 13s, and again, small businesses can file Chapter 7s as well. But in terms of consumer bankruptcies, it did a couple of things that were important. Number one, I've heard people refer to them as stimulus checks. Any checks that were appropriated by Congress and disseminated to taxpayers as a form of relief to help them manage the stay-at-home orders and the impact of the virus, those particular payments are exempt from your bankruptcy estate. So you're not going to have to account for any payments you might receive as a result of the CARES Act if you end up having to file for Chapter 7 bankruptcy. It also excludes from disposable income any payments you might have received as a result of the CARES Act, and it permits Chapter 13 debtors, when you're in bankruptcy, they call you a debtor. It excludes Chapter 13 debtors from certain requirements that their bankruptcy be wound up in a certain amount of time. So if you were in bankruptcy, in a Chapter 13 bankruptcy during the pendency of COVID-19, you can extend your payments that would have ordinarily have to have ended, say, in 3 years to 7 years. So because the understanding is that if you're not able to work during the pandemic because of a shutdown or because your job is not considered essential and was therefore not there, then your payment plan could be extended several years, up to 7 years, to allow you to be able to comply with the installment aspects of your Chapter 13 plan. Strategy 4, Chapter 13 bankruptcy. So if you've explored strategies 1, 2, 3, and you find yourself still needing relief, Chapter 13 bankruptcy will be step 4 of the strategy, and you really have to explore whether or not it's best for you. Chapter 13 bankruptcy the first thing to know about it is that it imposes an automatic stay on all collection activity. So once you file your bankruptcy petition, any creditor who calls you at that point, being mindful of the fact that you are in bankruptcy, risk violating the automatic stay. And I've seen judges impose $10,000 fine for people violating the automatic stay. So if you file bankruptcy and you get a collection call, let's say 3 or 4 days later, and that creditor has received notice that you filed bankruptcy, you may find that creditor will hang up the phone the minute you say, I'm in bankruptcy, because they don't want to be found in violation of the automatic stay. It's serious business. But that's the most important thing. And the idea of that is that when you're in bankruptcy, you're under the protection of the court now, and the court is going to make sure that your debts and your assets are administered in the best interest of creditors and within the law of the bankruptcy code. So the automatic stay is the first thing to know about it, and that's it's really powerful, and it extends even after your discharge. So if you have a debt that was discharged in bankruptcy court years ago, and a creditor calls you years after you've emerged from bankruptcy court trying to collect it, they could stand in violation of the automatic stay and could, suffer penalties if that was brought to the court's attention by a proper motion. Chapter 13 takes longer than a Chapter 7. It could take 3 to 5 years. And as I indicated earlier, under the CARES Act, it could be extended up to 7 years under certain circumstances. But 3 to 5 years to pay back your debts. Now, your debts have to be part of a Chapter 13 plan. The payback plan has to be feasible. And the debts in a Chapter 13 are broken into tiers. The top tier debts are debts that are secured by property. So, for example, if your home is, if you have a mortgage on your home, those type of things, if you still owe on your vehicle, those type of debts are at the top tier of the feasibility, payback plan, because in the event you don't pay back those debts, those properties, can be seized. So obviously you're going to probably end up paying those back close to, if not the exact amount of what you owe. Other debts that are not secured by collateral, credit card debts, those are going to be on kind of the bottom tier, and those will be paid back pennies on the dollar. But the plan has to be approved, and every creditor that you owe will have the opportunity to object and say the plan is not feasible. They can have, they can create situations where you have to appear at depositions and answer questions, about your finances if someone has reason to suspect you're not disclosing everything. Or if you pay back someone, let's say you pay back your brother who you owe money to the detriment of creditors. So you pay this person back before you file, and someone finds out about it, you can get in a lot of trouble if you didn't report that. And of course, if you did pay certain people prior to filing, sometimes those monies that you pay will get clawed back by the bankruptcy trustee for the benefit of those creditors. So, but the bottom line is that there's a plan. It has to be feasible. There are tiers to who gets paid back first and at what percentage. You have to make sure that you make those payments on time, and that you're communicating through your counselor or whoever is assisting you with that to ensure that you're meeting all the requirements of the plan. And of course, oftentimes Chapter 13s are converted into Chapter 7s because during the pendency of your Chapter 13 plan, circumstances might change. God forbid somebody gets sick and you end up not being able to work, or something happens, and you may then find yourself qualifying for a Chapter 7. And you should note that a lot of people file Chapter 13 because on the other side of that Chapter 13, your credit is in a little bit better shape than a Chapter 7, because in a 13, you've actually paid back your creditors as agreed. So your financial position and your credibility, your standing, as a person, as a consumer, is a lot stronger in a Chapter 13. So that's the reason why Strategy 4 is not Strategy 5, because it's something you need to consider before you consider liquidating everything. Is there a way I can pay back my creditors, in a plan and a framework in a matrix that makes sense, as opposed to trying to quickly rush to, to jettison all my debt and liquidate everything, because many people are not able to file a Chapter 7 because of the fact they're working and they make too much money. And there's a means test for that, and I'll talk about that in part 3. But many people are not able to file a Chapter 7, and they must file a Chapter 13 because they're a little bit better off than someone who's really in dire straits, and let's say doesn't have a job at all. So Chapter 13 has some benefits. There's some restrictions on it, and you really do have to be rigorous in terms of making your payments. in a timely fashion, or unless you serve, you stand to possibly be discharged involuntarily from Chapter 13 in the bankruptcy court because you're not complying with the strictures of the plan. So it's very difficult for a lot of people, and as I indicated, some people over a period of time, the situation worsens and they end up having to convert that 13 to a 7. But if you can follow the strictures of it and follow the plan, you're going to be a lot better off than you were had you filed a 7 in the eyes of creditors, in the eyes of anyone that looks at your credit report. And again, with a 7, you're looking at 10 years potentially having that mark on your credit report, whereas with a 13, you'll probably only have on your report 7 years because you've already spent 3, in bankruptcy court in a Chapter 13. So that's important to know. Now, the last thing about 13 I want to mention is that, as I've indicated before, certain tax debts, child support, certain type of agreements to pay spousal support, any type of criminal conviction that carries with it a fine or restitution, those are not dischargeable in bankruptcy court. Neither are student loans, except for extreme hardship. So there are certain things that you have to know about your circumstances before you actually file to make sure that it is the right fit for you. Now, strategy 5 is Chapter 7 bankruptcy. Again, if you don't qualify for a Chapter 7, it'll be because you make too much money. And that's something that the U.S. government has carved out and labeled the means test. And the means test looks at the average or the average income per state, and it's a separate category for people in the U.S. military. But if you're not in the U.S. military, they're looking at your income per state. So the income you need to qualify, say, in Alabama, is not the same income that you would need to have to qualify, say, in Silicon Valley, or in California or Washington State somewhere. So, in other words, the mean income in Alabama is lower than, say, it would be in Silicon Valley. So, as a result of that, the income that's considered average or the mean for people in that particular state is going to be lower. Therefore, the threshold required to file Chapter 7 in Alabama is different than it is in California. So all the states vary. Very few have the exact same amount. Some are very close, but typically, if you are not able to fall within that threshold for your state, you're not eligible for Chapter 7 unless there are certain exceptions that are employed to take into account your special circumstances that might then allow you to qualify. And I'll talk about that more in part 3 of this series. But for the purposes of this discussion and strategy 5 of avoiding bankruptcy and getting your financial affairs in order to address and prepare yourself and survive the pandemic era, Chapter 7, you have to know that there's a means test you have to take in order to qualify. But the good news is that if you go into Chapter 7, you meet the means test either through, kind of a prima facie, they kind of call it a prima facie test, meaning you just kind of take your income, the number of people in the household, and you fall below the threshold that's set by the U.S. government using aggregate statistics per state, then you can file and you'll emerge from that bankruptcy more likely than not owing anybody anything. So you get a complete fresh start. All your debts are liquidated. The automatic stay that I mentioned in strategy 4 applies to both, really all forms of bankruptcy. So creditors aren't able to harass or call you during that period of time, or ever after, if you receive a discharge of those particular debts. And most Chapter 7s are actually what they call no asset bankruptcies. People go into their Chapter 7, they're in dire straits. There might have been a health crisis, or in this situation, you might have been forced to stay home for 90 days or so and unable to work, or your job may not have been available because it was considered non-essential. So you didn't have income during that time, and you may have received some money pursuant to the CARES Act, but it wasn't sufficient to cover your expenses. And as a result of that, you find yourself in the unfortunate position of having to seek relief from the bankruptcy code. Well, in those circumstances, chances are you're going to come out of the other side of that Chapter 7 in roughly 2 months, sometimes 6 months, depending on how clogged the docket is at the bankruptcy court, or how complicated your bankruptcy is, or how many people, if any, file objections and try to challenge, some aspect of your schedule that you have to file in a Chapter 7. But nevertheless, on the other side of it, you don't owe anything. Now, an asset bankruptcy, as opposed to a no asset bankruptcy, is when you actually have high value assets. You were doing really well prior to the pandemic. Let's say you had a couple of Rolex watches. On the other side of that bankruptcy, you're not going to have those Rolex watches anymore. Those Rolex watches are going to be essentially taken and sold for the benefit of your creditors. But for most people, they just have normal household goods. They have, their furniture. They have, dining room, living room set. Bedroom sets for the kids, microwaves, that kind of thing. Maybe they have a car, maybe they don't. But chances are you're going to come out of that not owing anybody anything. You'll probably keep everything that you had going into it, because there is a state exemption or federal exemption that accounts for that asset, and including your retirement accounts are exempt, for example. And again, you can keep a certain dollar amount of cash on hand. Your children's 529 plans, for example, are exempt. But again, I'll talk about that more in part 3.
Surviving COVID-19 Part 2. In this part, I will talk about debtors versus creditors. What are some of the risks associated with settling debts or ignoring your debts? So the first thing to think about when you're considering settling a debt is to first determine whether or not you actually owe the debt. So there are certain categories of debts that you may not owe, and I will talk about some of those. But at the point when you're ready to settle a contract, or if you're about to consent to a judgment, or even if after the judgment or before the judgment you want to enter into an installment agreement with the creditor, you need to make sure that you actually owe the debt, because you may not have to actually pay it. Here's a list of debts that you may not owe. First is where the seller breached a warranty. So if you purchased an item and there is a warranty on that item, and the warranty provides that if the item breaks or another condition covered under the contract when you purchase the item is triggered, then you may not have to honor the contract, because the contract may have voided under its own terms. The second is where you're indemnified under an extended warranty. So a regular warranty would just be possibly over a short period of time, maybe 30 days, maybe a shorter period of time. But where you're indemnified under an extended warranty, the warranty will cover a period of time specific. So on a date certain, the extended warranty will void on its own, or it would end on its own terms. As long as you're under the umbrella of the extended warranty, chances are you may not owe a debt if a condition under the warranty was triggered such that creditor can no longer come after you for failure to make a payment. So in other words, the warranty may provide that if a certain condition is triggered, you no longer are obligated to make certain payments. And indemnification essentially means that some other party other than you is going to take responsibility for the cost covered under that condition that has been triggered. So for example, if you bought a vehicle and the extended warranty says for the first 5 years after the purchase of the vehicle, certain items, if they were to break, are to be repaired by the seller or another entity under contract or subcontract with the seller, then you would not be required to make any payments because of the extended warranty defense. The third condition under which you may not owe a debt is when you buy a brand new car. Most brand new cars are covered under the federal lemon law, and that is the Magnuson-Moss Warranty Act. The Magnuson-Moss Warranty Act is a federal law that provides recourse for anyone who has purchased a car that repeatedly fails standards of quality and performance, and as a result of that is considered a lemon. This typically only covers new vehicles. There are state laws that may supersede or provide additional rights and guarantees that the federal law does not, but just in case your state does not have a lemon law, the federal lemon law, the Magnuson-Moss Warranty Act, would cover a newly purchased vehicle. Now, to qualify under the federal lemon law, you must generally have a defective product that has suffered multiple repairs or attempts to repair it under the manufacturer's warranty. There's that warranty term again. Under the federal lemon law, lemon owners receive a cash award and can keep their vehicle, but cannot receive a free replacement vehicle. So, in other words, they're going to reimburse you for the damages or the loss suffered, such that under the Magnuson-Moss Warranty Act, you're considered to have been made whole, but you don't get a brand new car with that. You simply have to live with the car you have, with the idea that the manufacturer or the seller would have to repair the vehicle and bring it up to the standards for which you bargained. The fourth item in the list of debts that you may not owe is when you're a victim of fraud. When you're a victim of fraud, typically that voids any contract that you may have entered into. So there are two concepts here. One is void and the other one is voidable. A voidable contract is one that a court might determine is not an enforceable contract because of some condition or some defect in the formation of the contract. When a contract is void from the beginning, they call it void in initio. When a contract is void from the beginning, essentially what's happening is the law will say that the contract is not valid in and of itself and that it is not enforceable. So in the case of fraud, if fraud was used to induce you to purchase an item, then that contract is void and it is not enforceable. So if the contract was entered into under false pretenses, meaning the seller basically made a material misrepresentation as to what was going on with that particular item that you purchased, the state law in every state in the republic would say that that contract is not enforceable and is void. Here's a continued list of debts that you might not owe. The first is where you have a right to cancel a contract. The second is when the goods ordered were by mail, phone, computer, or facsimile. The third is when the goods ordered were done by phone and there was a phone solicitation to which you responded and entered into a deal to purchase an item. Now, the Federal Trade Commission has listed on its website numerous pieces of information to help you understand when you can and when you cannot cancel a contract. Many federal and state consumer protection laws allow you to cancel a contract, typically pretty much for any reason. They refer to that as a cooling off period, and sellers of goods are required to allow consumers a cooling off period to determine if in fact they want to keep that item. There are also similar laws in every state and republic that protects consumers from having made a purchase possibly by impulse, and sellers are required to provide consumers with a cooling off period. Now, in addition to that, the government can cancel certain kinds of contracts. For example, the federal law allows you to cancel contracts for second mortgages or refinanced mortgages. Not your primary mortgage, but your second or refinanced mortgage. Under the federal law, you can cancel a contract for a second mortgage or refinanced mortgage within 3 days of signing it. This does not allow you to cancel a contract for a mortgage on your home. Now, the buyer's remorse or the cooling off period that is mentioned in federal law, again, if you go to the Federal Trade Commission website, you can easily find this. Just run a simple Google search for cooling off period in FTC, Federal Trade Commission, and you'll find it. The FTC's cooling off rule gives you a 3-day right to cancel a sale made at your home, workplace, or dormitory, or at a seller's temporary location. For example, if you went to a fair, a trade fair or something like that, and you purchased something under contract at a temporary location that the seller had put up in a booth, for example, or a fairground or a convention center, restaurants, these type of things. So if it was a temporary location of the seller, the Federal Trade Commission's cooling off rule, 3-day right of cancellation would apply to that circumstance. However, it's important to note that not all sales are covered. That is to say, there are certain kinds of sales that cannot be canceled. For example, if the sale was for goods that are under $25 and you made that sale at your home, it does not cover sales that were $130 or less and made at a temporary location. It would also not cover goods that were primarily intended for personal, family, or household purposes. However, the rule does apply to instruction or training. The rule does not apply to sales made entirely online or by mail or telephone. It does not cover sale of goods that were provided to you to meet an emergency. It would not cover repairs made to your personal property at your request. Additionally, if you entered into a negotiation with the seller at the seller's permanent place of business where the goods are sold regularly, the cooling off rule would not apply to that either. If you ordered your goods by mail, phone, computer, or facsimile, sellers are required to have a reasonable expectation that they can get the goods to you within 30 days. Direct marketers sometimes call this the 30-day rule. So if you order goods by mail, phone, computer, or fax, and they don't arrive within 30 days of the sale, then technically you're allowed to cancel that order. Now, goods ordered by phone from a solicitor. Now, there's no particular federal rule that governs canceling a sale made of a good ordered by phone from a solicitor. In other words, someone calls your home and they're trying to sell things to you. Now, there are do not call lists, federal do not call lists, and if you're on the federal do not call list and someone calls you, there are rights of action regarding that call. But there's no particular rule in the federal domain that allows you to cancel something that you ordered after someone solicited you by phone. However, there are many state statutes that allow you to cancel goods that were sold to you by a telephone solicitor. In some states, for example, they allow you to cancel the order by midnight of the third day after the sale is made. But again, that's not something that's available to you on a federal or national level, but many state legislatures have enacted telephone solicitation acts that will allow you to cancel certain goods sold to you by a telephone solicitor. However, you have a very short period of time to cancel that order. In addition to the list of debts that you may not owe, there are other remedies that may help you to cancel a debt that, in fact, you should not have to pay. And that is, first of all, the debt validation process. And the idea of the debt validation process is if you receive notice that you owe a debt, you are allowed to send the creditor a letter requiring them to validate the debt within 30 days of receipt of your letter. If they fail to respond within 30 days of your letter, they are prohibited from reporting that debt to the credit reporting agencies. Now, many debts you'll find have been sold many times after origination. So you may purchase something from your local appliance store on credit only to find out later that that particular contract was sold to someone else. It may have been sold to a bank. It may have been sold to a private investor. If you receive a letter from someone who subsequently purchased your contract and you send them a debt validation letter, they must prove that they in fact own the rights to collect that debt. So it's not sufficient for them to say, well, we purchased a debt from the local appliance dealer. They have to show that they in fact own that debt, and they have 30 days to do so. But above all, before you actually pay a debt, you need to make sure that the applicable statute of limitations has not in fact run. Most contracts usually expire after 6 years. Now, an exception to that would be a mortgage, for example. Most mortgages are good for 15 years, which is to say the creditor has up to 15 years on a mortgage, typically in most states, to sue you or to foreclose on the mortgage loan. But aside from that, most debts and most contracts for goods and services will expire after 6 years. So if the creditor waited 6 years before coming after you or trying to collect the debt, then more than likely the statute of limitations has run and that contract is no longer enforceable. Now, come after you does not mean they're calling you. It does not mean they put a collection agency onto you. What it refers to is they've actually filed suit in a court of competent jurisdiction to collect the debt. So if they wait more than 6 years to file a suit, then typically that contract is going to be void. And again, I make the exception of a mortgage, for example, which typically is 15 years. In addition to the statute of limitations issue, there's also the fact that credit reporting agencies are restricted by law from reporting a debt that's over 7 years old. So if you signed a contract 7 years ago, the goods were delivered 7 years ago, and the debt is for some reason in default, the credit reporting agencies are not allowed to report that debt legally after 7 years. If you look at your credit report and you find a debt that's over 7 years old on your credit report, then you have a right to challenge that credit report or at least that entry on your credit report. It's important to note, however, that just because something isn't on your credit report or because the credit reporting agencies are not allowed to report something by law, that does not stop the creditor from suing you in court. What are the consequences of ignoring your debt? Now, just because someone is calling you and they're being obnoxious on the phone or they're calling you repeatedly does not mean you can ignore them. There are rules that govern harassing phone calls, repeated phone calls, or certain types of phone calls when you are on the do not call list. However, if you ignore your debts, dire consequences will arise. And of course, among those dire consequences, you find things like evictions, foreclosures, repossessions, prejudgment attachments of unsecured property, lawsuits, liens on your property, jail, of course, bank set-off, garnishments. Garnishments are devices used by creditors to collect money due to you that's in the hands of a third party. For example, if your wages are garnished, the creditor runs to the courthouse, gets what's known as a writ of garnishment, serves that writ on you and on your employer, or it could be a bank, or it can be the state treasurer who's holding your state income tax refund or credit. That third party is then required to notify you that your funds are being held pursuant to a writ of garnishment, and you would usually have maybe 21 days, maybe a little longer, according to the state law, to respond to that and try to convince a judge that that writ is inappropriate, either because the amount of interest was improperly calculated, or because you actually paid the debt, or because you were excused by some other condition. If in fact the court finds that the creditor's claim is legitimate, then what's going to happen is that you're going to experience either a complete liquidation of your, say, bank account to the amount of the writ. So if you owe $3,000 and you have $3,000 in your bank account and the writ is served on your banker, then that $3,000 in your bank account is going to be forfeited and given to the creditor. Writs on employers are slightly different. Most states put a limit on the amount that may be garnished from a person's salary. For example, in some states, 25% of your wages can be garnished and surrendered to your creditor, but obviously garnishment served on any person holding or any entity holding your assets is a serious matter. Another thing that can happen if you owe a creditor is that your income tax refund or credit may be intercepted from the state treasurer. I mentioned that process earlier. It's essentially another form of garnishment, but it's treated slightly differently because of the nature of the funds. You could suffer a loss of your insurance coverage, and or you can suffer the loss of your utility service. If you're in default and creditors are calling, I would urge you to go back and watch my second video, Reducing Your Exposure to Lawsuits and Seizures. In that video, I talk about the very consequences I mentioned above, in particular garnishments, repossessions, and also dire consequences associated with a court finding you to be in contempt of court for either not answering a summons or not complying with an order to pay your creditor.
This is part 3 of a 4-part series. In part 3, I will cover Chapter 13, Bankruptcy. This constitutes Strategy 4 for getting your debts back under control. In strategy number 3, I talked about consumer credit counseling. Chapter 13, Bankruptcy, is appropriate to explore if you looked into consumer credit counseling and discovered that it is not for you, or if you discovered that it does not completely resolve your issues with your creditors. If you're eligible for Chapter 13, Bankruptcy, as I've indicated earlier in a previous video, the Chapter 13 bankruptcy petition will impose an automatic stay on all collection activities. Now, while doing a Chapter 13 bankruptcy takes longer, the creditor is in a little better standing than it would be if you filed a Chapter 7, which is a liquidation. I will talk about Chapter 7 in Part 4, which is the final part of this series. As I've indicated previously, if you file a Chapter 13, you will have 3 to 5 years to pay off your debt. But as I've indicated in a previous video, on March 27th of this year, President Trump signed the Coronavirus Relief, Aid, and Economic Securities Act, which did modify in significant ways Chapter 13 of the Bankruptcy Code. I will address that shortly. Before getting into the specifics of Chapter 13, I want to make at least one thing clear about the use of the term bankruptcy. Sometimes people use the term bankruptcy synonymously with insolvency. Bankruptcy refers specifically to proceedings in the federal bankruptcy court under the U.S. Bankruptcy Code. Now, I've mentioned earlier there are several different kinds of bankruptcy, and when people refer to Chapter 7, Chapter 13, or Chapter 11, they're referring to specific chapters of the Bankruptcy Code. Now, Chapters 1 through 6 include provisions for filing a petition for relief in bankruptcy court. It also includes general definitions, things of that nature. Chapters 7, 11, 12, and 13 are the primary chapters. Those are the chapters that provide debtor relief. Also, as I've mentioned in earlier videos, Chapter 7 is a complete liquidation of your debts. So when people talk about a fresh start, people are referring to Chapter 7 proceedings. Chapter 11 is used for both business and individual reorganizations. Chapters 12 and 13 are specialized reorganizations for farmers and individual wage earners. Now, there are some things you must consider before filing. As I've indicated previously, the following obligations are either difficult or completely impossible to discharge in bankruptcy. The first is a government student loan. That is to say, a loan for which you receive government assistance. The second is alimony, or domestic support obligations. These also include child support obligations. The fourth is court restitution orders, or orders from a court that you pay restitution, usually arising from a crime, but sometimes even from civil judgments you might be ordered to pay restitution. The fifth are criminal fines, and the last one are certain taxes, usually from a state or federal taxing authority. Now, oftentimes when people file bankruptcy or they contemplate filing bankruptcy, questions arise as to whether or not they're judgment-proof. Judgment proof refers to a situation in which certain state or federal statutes render your assets immune from execution, levy, or garnishment. Sometimes Social Security proceeds are considered judgment proof. However, there are ways of getting around this so-called judgment-proof status. For example, if your Social Security proceeds are deposited in a bank account, many times the fact that they're in that bank account and perhaps mingled with other assets may strip them of their so-called judgment-proof status. Additionally, certain pension funds, certain retirement funds that are not covered by ERISA are oftentimes not considered exempt from execution. In addition to that, when creditors are not able to seize assets that are supposedly judgment-proof, they will quickly find other ways of collecting a debt. For example, seizing vehicles and other assets, to include state income tax refunds or credits. Consequently, the idea of something being judgment-proof or an asset being judgment-proof or proceeds from Social Security or retirement funds being judgment-proof will not entirely rescue you from creditors who are determined to collect. Next, we look at who may file Chapter 13. For cases filed on or after April 1st, 2019, a wage earner and their spouse or a non-business entity may file Chapter 13 if all three of the following are true. First, the unsecured debt must be under $419,275. And finally, the wage earner and his or her spouse have to have received credit counseling from an approved credit counseling agency within 180 days of filing the petition. Now, an approved credit counseling agency is one approved by the bankruptcy court. I will place a link in the description box that takes you to the federal bankruptcy court, where you can find the links to approved credit counseling agencies. And as I previously indicated, the CARES Act enhances the protections under Chapter 13 by doing three things. First, it amends the definition of income to exclude federal coronavirus-related payments. Second, it excludes coronavirus-related payments from the calculation of disposable income. Third, it extends the total amount of time for a repayment plan from 5 years to 7 years. So ordinarily, you would have had a maximum of 5 years to repay your debts under a Chapter 13 repayment or reorganization plan. But under the CARES Act, you now have 7 years under many circumstances. A small proprietorship business may also file Chapter 13. The eligibility threshold is $2,725,625. However, the CARES Act raises the threshold to $7.5 million. This $7.5 million threshold will return to the $2.7 million threshold in 1 year. Next, we must look at who may not file Chapter 13. The following persons may not file Chapter 13. A debtor who received a discharge under Chapters 7, 11, or 12 in the last 4 years, and a debtor who received a discharge under Chapter 13 in the last 2 years. Now, what happens first when you file your Chapter 13? Well, the first thing you have to do is you have to complete an official bankruptcy petition. That is to say, the statement of financial affairs and all of the schedules. And the schedules contain the following information: who your creditors are, the amount you owe them, and the nature of your creditors' claims, the source, amount, and frequency of your income, a list of all of your property, and a detailed list of your monthly living expenses. Now, the main event in filing your Chapter 13 petition is filing the reorganization, also known as the repayment plan. Now, your repayment plan is designed to do something really important, and that is to pay a specific amount or percentage to your unsecured creditors for 3 to 5 years. And as I indicated earlier, the 5 years is expanded to 7 years. The amount or percentage of the payments you make on a monthly basis to your creditors is based upon your monthly income. However, the most important part of the repayment plan is the liquidation analysis. The liquidation analysis is used to determine the amount or percentage that you will actually have to pay. In order to conduct the liquidation analysis, that is to say, who gets paid what first, the creditors are divided into classes. And there are essentially 3 classes. They are priority claims, secured claims, and general unsecured claims. So your priority claims include things like domestic support obligations, taxes, and costs assessed by the bankruptcy court itself. These claims are given first priority and must be paid in full, meaning there's not going to be any pare down or compromise with respect to these priority claims. On the second tier are your debt secured by collateral. If you purchased an item, say a car or a house, and the lender took back a security interest in that item, the lender now has the right to seize that item if you're in default on the loan. So in many cases, the debts that are on the second tier in order of priority will also have to be paid back in full. The difference is, and one of the benefits of Chapter 13 over, say, a Chapter 7, is that if you enter into a plan to pay back your mortgage, for example, chances are you're not going to be able to pay it back in 3, 5, or even 7 years. In such case, that particular debt will survive the length of your reorganization plan. So you would carry that debt, or you would maintain that debt into the future, far beyond possibly the life of your bankruptcy experience. But the benefit, obviously, is that you'll be allowed to keep that asset moving forward. Third-tier debts are debts owned by creditors with no special right of collection against a particular property. So there is no security interest in that particular item. They simply loaned you the money, and you purchased the items from a third party with no involvement from the creditor. In these situations, the creditor has no right to seize or otherwise attach their property as a consequence of having loaned you the money. A prime example of this type of creditor are credit card companies, where you simply had a line of credit and you went out and purchased items. Now, a liquidation analysis is conducted in consultation with accountants, and it measures how much you will be able to pay. Assume, for example, you have $1 million in assets and $1 million in debt. And assume further that accountants determine that a forced sale of your assets would bring $500,000. That is to say, $500,000 left to pay your $1 million in debts. As a result, the best a single creditor could do would be 50 cents on the dollar. Now, things get complicated if you have creditors divided into classes. That is to say, priority claims, secured claims, and general unsecured claims. That is to say, a liquidation analysis has to be done for each class of creditor. Now, there are some key time frames associated with a Chapter 13 bankruptcy. As I indicated earlier, you're required to complete credit counseling prior to filing your bankruptcy petition. Now, this is the case both for a Chapter 7 and a Chapter 13 bankruptcy. But in a Chapter 13 bankruptcy, the counselor may actually sit down with you and carve out a debt repayment plan. If so, you have to submit that debt repayment plan together with your credit counseling certificate. In addition, you have to submit any payments from employers that you may have received within 60 days of your filing. The next crucial deadline is the meeting of creditors. The meeting of creditors is conducted by the bankruptcy court trustee between 21 and 50 days of your filing. The next crucial time frame is the proof of claim. Unsecured creditors must file their claims with the court within 90 days after the first date set for the meeting of creditors. In a previous video, I talked a little bit about the first meeting of creditors. The first meeting of creditors typically occurs in something closer to a conference room than a courtroom. When you enter the bankruptcy court, there are docket sheets outside of the various conference rooms inside which the meeting of creditors are occurring. The meetings of creditors are typically conducted alphabetically. When you enter the conference room, you'll see a number of other persons who are also there for the same purpose, and the trustee is usually seated at the conference table. When your name is called, you and your attorney, if you have one, approach the table with your driver's license and copies of your schedules. The next thing that happens is the trustee will administer an oath, and then the questions will begin. Occasionally, when you approach the table, you'll notice other people standing up and coming to the table. Those persons are probably your creditors as represented by their attorneys. They may also have questions for you after the trustee is done. So it may be the case that when you attend your 341 meeting of creditors, many of your creditors have already filed proof of claim. But again, this proof of claim must be filed within 90 days of your filing. The next key time frame is the repayment plan. The repayment plan may have been filed with your petition, but if it hasn't, it has to be filed within 14 days of the petition being filed. Occasionally, the court might grant you an extension to file that repayment plan, but if the court does not grant you an extension, it has to be in within 14 days of your filing, or your petition may be dismissed. Then, within 30 days of the filing, you have to start making payments to your creditors pursuant to the plan that you filed. And this remains the case regardless of whether the court has approved your plan or not. Next, within 45 days of the meeting of creditors, the judge is required to hold a confirmation hearing and decide whether or not your plan is feasible and meets the confirmation standards. Very common in Chapter 13 are objections from creditors. And what the creditors are objecting to is your ability to discharge their debt. Now, creditors receive 28 days notice of your confirmation hearing and may object prior to. Now, creditors receive 28 days notice of your confirmation hearing but may object well in advance of that hearing. The most frequent objections are as follows. The first is when your offer to make payments is less than the creditor would have received had your asset been sold by force. And the second is when your plan does not commit all of your projected disposable income for the applicable 3, 5, or 7-year commitment period. Finally, once your plan is approved by a judge, you must begin to work the plan. Now, the important thing to know about that is that both you and your creditors are bound by the plan. Further, they're not allowed to contact you directly and must deal directly with the trustee. Second, you have to make each and every one of your payments on time. But again, one of the key benefits of filing a Chapter 13 is that you're allowed to keep your property as long as you're making payments. And fourth, you may not incur any new debt without consulting the trustee first. And the reason for that is that if you are allowed to incur new debt while your plan is still in motion, any new debts could jeopardize your ability to successfully execute the plan. One of the pitfalls and risks of Chapter 13 is the possibility that your petition may be involuntarily dismissed. Now, your petition can be dismissed if, for example, a deficiency appears in your schedules or your filings, and you don't timely rectify those deficiencies. The court will dismiss your petition. The court may also dismiss or involuntarily convert your Chapter 13 into a Chapter 7 if any of the following happens. You fail to pay any post-filing domestic support obligation, meaning you fall into arrears in child support or alimony, or you fail to file state or federal income taxes when required. Having made all your payments on time and not triggered any of the events that would cause the court to dismiss your petition, you are entitled to a discharge provided all of the following are true. You completed all of your payments under the 13 plan. You certified that all domestic support obligations, if there were any, were paid. You have not received a discharge in a prior case filed within a certain time frame. You completed an approved course in financial management. Now, the approved course in financial management is different from the credit counseling course. The credit counseling course you must complete before you file your petition, while the financial management course is done after you file your petition. But it must be completed before you receive a discharge. No one has sued you to challenge your claim for a homestead exemption. Now, I mentioned this in previous videos about avoiding bankruptcy and why bankruptcy may not be for you, and why you need to have a thorough analysis of whether or not the debts from which you are seeking relief are even dischargeable in the first place. If you're filing Chapter 13, chances are you do not want to lose your home. So obviously, if you have a 30-year mortgage, you're not going to look to have that discharged, which is to say paid off. You're not going to look to have that paid off in 3 to 5 or 7 years while your petition is before the court. Again, domestic support obligations are not dischargeable. Alimony and child support. Certain taxes, state and federal, are not dischargeable. Government-funded student loans are not dischargeable except for extreme hardships. So I always tell people, if you have a government student loan, you should probably plan to keep it. If you received a conviction for driving under the influence and debts arose from that conviction, those are not dischargeable. If you were ordered to pay restitution as a result of a criminal case, that restitution obligation is not dischargeable. If you incur a debt and the debtor is able to subsequently prove that you secured the loan from them under false pretenses, and that is to say they demonstrate that in court, you will not be able to discharge that debt either. The most common example of that I've seen, and I've litigated this myself, is when someone borrows money, say from a bank, and on their loan application, they may embellish their educational credentials in order to make themselves more attractive as a loan prospect. At the point that debtor defaults on the loan, oftentimes there will be a review of the file, including the credit application. If the debtor on his or her application embellished facts, and those facts are shown to have induced the creditor to loan the debtor money, then that credit was extended under false pretenses, and if adequately demonstrated to the bankruptcy judge, you may not experience a discharge for that particular debt. And as a matter of fact, if the court deems your behavior to be egregious enough, the petition could be dismissed. Finally, there is such a thing as a bankruptcy hardship discharge. Now, a bankruptcy hardship discharge may arise if someone is seriously injured and unable to work, or they become gravely ill, which renders it impossible for them to work. Under these circumstances, the debtor cannot be expected to faithfully discharge the plan. Now, there are some strictures that the court applies to hardship discharges. First, the hardship discharge would not be available if that debt was not dischargeable in a Chapter 7 proceeding. Further, the debtor has to show that the circumstances giving rise to the request for a hardship discharge are beyond the debtor's control and through no fault of the debtor. Also, debtors have to show that creditors received at least as much as they would have received in a Chapter 7. Finally, the debtor has to show that modification of the plan is impossible. And the last thing is, can you do this without an attorney? Well, as I've indicated in other videos, you most certainly have the right to file on your own. They call that being a pro se litigant. However, because of the long-term financial consequences associated with filing bankruptcy, I strongly recommend you seek advice of a qualified attorney. Indeed, an attorney can advise you on things like whether you should file a bankruptcy petition in the first place. An attorney can help you determine what particular chapter of the bankruptcy code best meets your needs. An attorney can help you figure out whether or not the debts that you're worried about are even dischargeable. An attorney can help you figure out whether or not you'll be able to keep your home, car, or other assets that are important to you. An attorney can help advise you as to the tax consequences of filing. An attorney can help you figure out when it's appropriate to stop paying your creditors. He or she can also help you understand the bankruptcy law and procedures. And if nothing else, an attorney can help you fill out the very complicated and complex forms that are associated with filing bankruptcy.
Today I will cover part 7 of my 4-part series on surviving financial challenges during the COVID-19 pandemic. In the first 3 parts, I talked about determining whether or not bankruptcy was in your interest in the first place. And I also mentioned that in my estimation, filing bankruptcy should be a last resort when lesser means have failed, or it was determined by you upon a proper analysis that it was not in your best interest to file bankruptcy. So in the prior sections, I provided tools and tips for viewers to look at to determine whether or not this was the step you needed to resolve your financial challenges. In prior sections, I also talked about some of the enhancements to the bankruptcy process that were brought on by the CARES Act, which was enacted in March of this year as a response from the White House to the COVID-19 pandemic. But today I will talk about eligibility for Chapter 7 bankruptcy, do's and don'ts. But the meat of this video will be dedicated to the means test, which is probably the most significant aspect of filing Chapter 7, because the means test helps you determine whether or not you're eligible to file. If you're not eligible to file, then you'll have to perhaps look at another avenue of relief provided by the code, say Chapter 13, which I covered in Part 3. Now, it's important to understand that in 2005, the Bankruptcy Abuse Prevention and Consumer Protection Act radically changed the bankruptcy code in such a way that it made it more difficult for people to receive discharges in Chapter 7 bankruptcy. The goal of the Abuse Prevention and Consumer Protection Act was to prevent people from abusing the Chapter 7 process and to encourage more people to file Chapter 13, which I covered in Part 3. It did that by imposing a means test on all individual filers. Now, there is one key exception for disabled veterans who were injured in service to the country or in a homeland security capacity who incurred debt during that period of service. But aside from that, individuals whose debts are primarily consumer in nature will have to complete and successfully satisfy the means test in order to be able to proceed under Chapter 7 of the Bankruptcy Code. One other key provision of the Abuse and Prevention Act was to exempt from the assets in your bankruptcy estate Roth IRAs and certain other retirement assets. So first I'll talk about eligibility under the code. The thing to know is that an individual can file Chapter 7. However, when an individual files Chapter 7, he or she must complete and receive a certificate in credit counseling from a bankruptcy court approved credit counseling agency. Now, when we visit the bankruptcy court website momentarily, you'll notice that there's a tab for links to other sites. And if you click on that tab, it will take you to a list of bankruptcy court approved credit counseling agencies. Also among those who can file Chapter 7 are corporations, partnerships, and other business entities. However, business entities do not have to take the means test. So let's jump right into the means test. And rather than get into a long discussion about how the means test actually works, I'd rather go right to the site and do a simulated means test online. The place to start is to go to uscourts.gov. That's the website. Once there, you'll see a location tab. In the location tab, you want to type in your state. Once your state appears in the search bar, you click on that and it will take you to your state. Now, for purposes of this illustration, I'm going to just pick Alabama because Alabama is the first state alphabetically in the union, and it'll simplify the process moving forward. Now, once you click on your state, you'll go to the federal court finder, scroll down to find the specific bankruptcy court. court. And of course, you want to find one that's closest to and that serves your home. If you look on the right side of the page, you'll see a drop-down list for districts in Alabama, and we're going to select the Alabama Middle Bankruptcy Court. From here, you click on OK, and it will take you to the Middle District of Alabama's page. And while here, you can see there are various tabs at the top of the page. Over to the far right, you'll see a Related Links tab. If you were to click on that, it would take you to a list of approved credit counseling agencies. But while here, let's click on Fees and see how much it costs to file a Chapter 7. As you can see, the petition fees are listed here on this page. Chapter 7 is the first of the chapters listed, and the fee for filing a Chapter 7 is $335. We'll note incidentally that the fee for filing a Chapter 13 is $310, and these fees do include the court's administrative costs. If you look over to the left of the screen, you'll see that there's also a list of approved credit counseling agencies on this tab as well. So if you wanted to find a credit counseling agency closest to your home, that particular link is also provided on this page. And you simply click on that and it would take you to a list of providers, and from there you can determine which one is closest to you. Now, the means testing information or the means testing data is concerned with determining whether or not your income over the last 6 months is within the average income of individuals living in your state. And for purposes of the means test, the court relies on census data. In order to find out if your income is within that threshold, you need to go to justice.gov, a website maintained by the Department of Justice, where this information is stored and can be accessed for purposes of determining if you are within the threshold of individuals living in your state. So while on this page, you'll scroll down and you'll see a section entitled Data Required for Completing the 122A. That's the form that we're going to complete to help us determine whether or not we can file Chapter 7. And this information is also useful for completing Bankruptcy Form 122C, C as in Charlie. Beneath this title, you'll see a drop-down list that encompasses timeframes going back as far as 2005. And each of these timeframes captures data compiled by the Census Bureau for each state in the Republic for that time frame. Now, when you're looking to determine if you're going to be able to file Chapter 7, you want to pick the time frame that's most current, which is going to be the one at the top. And in this particular instance, it's May 1st, 2020. So you simply select that time frame, click go, and it will take you to another page. Now, on this page, you'll see means testing listed at the top of the page. And under that, you'll see that this is Census Bureau IRS data and administrative expense multipliers for cases filed on or after May 1st, 2020. Scroll down a little further and you'll see the title, Median Family Income Based on State, Territory, and Family Size. Beneath that, you'll see there's an option for downloading an Excel spreadsheet, which is populated with all of the national data for this time frame. But we're going to click on the median family income based on state or territory and family size. And here again, you see that at the top of the page, we're looking at census data compiled for purposes of cases filed on or after May 1st, 2020. Again, for purposes of this illustration, we're going to simply randomly pick Alabama, and the example that I will use to complete the required means testing form will be based on 2 individuals who live in Alabama. So at the top of the page, you notice that you have your states listed, and the states are listed alphabetically. And then across the table from left to right, we see the state median income for Alabama residents for the time period covered for 1 earner, 2 people, 3 people, and 4 people. Notice there's an asterisk next to the top of the column for household or family sizes comprised of 4 people. If you go down to the bottom of the table, the asterisk was meaning to point you to the addition that you need to make for every individual in the family in excess of 4. So for every person above 4 in your household, you would add $9,000 to the income you're permitted to make and still file Chapter 7. Notice also that every state in the Republic has a different average income per earner. So according to the Census Bureau, the most current data available for Alabama residents indicates that the average annual income for 1 earner was $48,544, and for 2 people, it's $56,918. In our example, there are 2 persons living in the home, so we're going to have to eventually populate the form with this number, 56,918. Now, the bankruptcy websites all contain 2 sets of forms. The first set are local forms, and the second set are official bankruptcy forms. The means test form, the 122A, is an official bankruptcy form. So we have to return to the website for the Middle District of Alabama, go to the Forms tab, and access the official bankruptcy forms. Now, once at the official bankruptcy forms page, there's another hyperlink to click on that will take us to a list of the forms. So we're going to do that. And once at the official bankruptcy forms page, you can see all of the forms that are available to filers for all of the chapters of the bankruptcy code. So not all of the forms listed here would be used in any particular kind of bankruptcy. They're all kind of mixed in, but the intent is to give each form a serial number and to list those forms alphabetically according to serial number on this page. So we're simply going to scroll down until we find the form that we need, and that is the B as in Bravo 122 A as in Alpha -1, which is entitled Chapter 7 Statement of Current Monthly Income. Over to the very right of that, you'll see the category of form that this is, and this is a means testing form, and this is the one we're going to select. Now, once on the form, you're simply going to populate all of the fields, and we're going to name our first debtor John Doe Mills and our second debtor Sally Sue Mills. Notice to the right of the box where the debtors indicate their names, there's another box containing 3 check boxes. And you see the very first one there says there is no presumption of abuse. So remember that, because we're going to need to come back to this box when we're done completing the form. Now, for purposes of this example, Sally and John are married, living together, but John is filing bankruptcy, Sally is not. Now, beneath the parties' names, you'll find the word United States Bankruptcy Court for the blank, District of blank. This is actually a drop-down menu provided by the court and embedded in the form that lists all of the bankruptcy courts in the Republic. So if you click on that area, you'll find all of the bankruptcy courts will be populated there in a drop-down list, and our court will be the first one. You simply click on that. We don't have a case number yet, so we simply will skip that stage of the form, scroll down. Because in our example, John and Sally are married, but Sally is not filing bankruptcy with John, meaning whatever debt she might have, she's going to keep, while John is looking to liquidate all of his debts. We're going to click married and your spouse is not filing with you. We're also going to click living in the same household and not legally separated. For the sake of simplicity, we're going to assume that John makes $1,500 a month and that he and Sally work in the same place and make the exact same salary, and that they have not experienced any unemployment for the last 6 months or had any other income other than their salaries. Now, typically when you do a means test, the way it's done is you go back over the last 6 months prior to filing, and you compile all of your sources of income for that 6 months. Now, because of this, timing of your filing can be crucial. For example, if someone is a seasonal worker and they're out of work as a function of the nature of their job for, say, 4 or 5 months out of the year, then those 4 or 5 months that they're not working, but maybe 4 of the 6 months that you want to include when you're filing Chapter 7, just in case your annual income taken as a whole would push your income beyond the state median income for the number of earners in your family size. But for simplicity's sake, we're going to simply say that John and Sally have not experienced any unemployment, and that every month they make the exact same amount. There's been no overtime to speak of, so their paychecks have been identical for the last 6 months. Now notice when you get down to line 4, we have to include Sally's income because she is regularly contributing to the household. If John and Sally were married and she was not regularly contributing to the household, then we would not be required to include her income. For example, if she was a stay-home mom and didn't have any income at all. But in this case, they're both equal earners and they're both equally contributing. The only difference is John's requesting relief under Chapter 7 of the code and Sally is not. That said, we're going to go ahead and populate all of the other fields with 0. And now we're on page 2, which requires you to list other sources of potential income, including unemployment compensation, pension retirement income, or income from any source not otherwise already listed above. Note at line 10, the form instructs that if you receive payments as a result of the CARES Act, need not be listed here. So those payments, if you received any, or if you receive any moving forward from the second stimulus package, those payments that were appropriated by Congress and signed into law by the president back in March need not be listed on this form as income. Now down at line 11, we're going to calculate monthly income for the last 6 months for both John and Sally. And of course, because we have no other sources of income, unemployment or anything else, we're going to just add the 15 to the 15, which gives us $3,000 per month for the household. And then at line 12A, we're going to re-enter that number again. Then we're going to multiply that 3,000 by 12, which gives us $36,000, which is, pursuant to the means test, the income for John and Sally's two-person household. Next, we go down to line 13. We populate this field with the state of residence, and below that with the number of persons in the household. And then at line 13, in the box provided, we're going to return to the census data form, which has already told us that the median income in the state of Alabama for the period covered for a two-person household is $56,918, and we're going to insert that number into box 13. Next, we drop down to line 14, where we're told that if line 12B is less than or equal to line 13, which is the census data number, we are to return to the top of page 1 and check the box indicating there is no presumption of abuse. So we're going to check box 14A, and we're going to note that had it been the case that line 12B, meaning John and Sally's annual income, had turned out to be more than the amount of the median income for Alabama residents with a two-person household, the presumption of abuse would have arisen, and we would then have to go and complete not only the rest of this form, but bankruptcy form 122A as in alpha -2, which requires a showing of special circumstances necessary to overcome the presumption that we were trying to abuse the code, essentially. So we return back to the top of page 1 as instructed. We check box number 1, which says there is no presumption of abuse, which is frankly the best news we've had since we entered the process. Then we go down to page 3, part 3, and both John and Sally have to sign and date the form at part 3. Now, just for purposes of illustration, let's take a look at official form 122A-2, which is the form John and Sally would have had to complete had their income been in excess of the state median for Alabama residents with two-person households. Now, notice that part 1 of the form requires a determination of John and Sally's adjusted income. Part 2 requires them to calculate deductions from their income. And part 3 requires a determination of whether there's a presumption of abuse. So there would have already been one presumption of abuse made in the hypothetical. But then as we approach the other form, which is the special circumstances test, at part 3, there's yet another test after having completed parts 1 and 2 to determine if we have overcome the presumption of abuse of Chapter 7 of the Code. Part 4 requires specific details about the special circumstances. Now, many special circumstance cases involve serious health problems that a debtor may have experienced. There may have been a family emergency that caused the family to fall into arrears with creditors, or to otherwise have to overextend themselves in order to care for an ailing family member or to deal with the family emergency. Part 4 is where you would give specific details of those circumstances. And of course, part 5 would be where you would sign and date. And again, if this was John and Sally's circumstance, they would both have to sign and date the form. Interestingly, the code does not define the terms household, family, or dependents. However, the bankruptcy court has developed some guidelines for purposes of determining for the means test the size of your family. And in essence, the bankruptcy court uses the census data to determine household size. The first thing that is looked at is whether or not the group of people have lived in that home for at least a year. Second is whether or not those individuals living in the home have pooled their incomes. And third is whether or not the persons living in the home acted as an economic unit. So in short, if John and Sally had 2 kids, for example, their household size would be considered 4 persons under this test. Now, there's some other things that the test presumes that may not have been demonstrated in the illustration I did because it was fairly simple. But the mathematics behind the test are that if a debtor's net income is over $12,850 or 25% of the debtor's non-priority unsecured debt, there's a presumption of abuse. And the whole idea of the presumption of abuse is that the mathematics behind the means test are supposed to flesh out whether a person could dispose of all of their consumer debts with relative ease. Now let's talk about individuals who are not permitted to file Chapter 7. First on the list are individuals who have filed Chapter 7 in the last 180 days and had their petitions dismissed for willful refusal to comply with an order of the court. The second is when the debtor voluntarily dismissed their petition or had their petition dismissed after a creditor sought permission from the court to go after the debtor's assets that were secured by a lien. An example of that would be if you had a note on your car, meaning you still had payments due, and in the contract you signed when you purchased your vehicle, you indicated that in the event you did not make your payments on time, the holder of the note was permitted to repossess the vehicle. And then you turned around and went into bankruptcy court with that debt still unsatisfied. The creditor then asked the judge to set aside your request to dispose of that particular debt. And then you noticed that that was happening and you asked the court to dismiss your petition, which of course is your right. You are not going to be able to refile a bankruptcy under Chapter 7. So in other words, the code presumes that you are abusing the process by trying to avoid paying your secured creditors. So how does Chapter 7 work? Chapter 7 begins with the filing of a petition, and the petition has to be filed in a state where you have resided for at least 6 months prior to filing. So if you recently moved, you're not going to be able to file in the district where you recently moved. You have to have lived in that district for at least 6 months before you file. That's the rule for individuals. Businesses, on the other hand, can file where they're organized. And as many people know, you can organize your business in one state and operate in another. Many businesses are Nevada corporations and they operate in California, or they may operate throughout the United States. So a business can file where they're organized, they can file in their principal place of business, and they can also file where a lot of their assets are physically located. In addition to your petition, you have to file your schedules, which include your assets and liabilities, schedules that reflect your current income and expenditures, the statement of financial affairs, which is the most extensive document that you need to complete as part of the Chapter 7 packet. And in that particular form, which is probably 15 or 20 pages long, if properly completed, you will detail all of your financial affairs for over the last 2 years or more, including how much you paid your lawyer if you chose to hire one to assist you with your Chapter 7. You also have to list all of the executory contracts that you have that are in effect at the time that you file your Chapter 7. Executory contracts are things like leases or other contracts that affect your property or your assets that have not been completed at the time you file your petition. And the most common example of that would be a lease, an unexpired lease. Now, interestingly, another aspect of Chapter 7 that would preclude the completion of the means test would be if most of your debts were not primarily consumer debts. And consumer debts are debts that you incur for personal or household or family purposes. For example, if you went and borrowed money from a furniture store, or you financed furnishings that you bought from a furniture store, those are classically considered consumer debts. However, if you owned a small business and you were filing Chapter 7, both on account of your small business debts and your individual debts, if the majority of your debts arose from your business, even though you might have a substantial amount of consumer debts, you would file that as a non-consumer Chapter 7, because that Chapter 7 would then be characterized as one that was not composed of primarily consumer debts. I already mentioned the credit counseling certificate. The credit counseling certificate is usually good for 6 months, but of course, most people will complete credit counseling and file days thereafter. Now, if during the credit counseling process, you sit down with a credit counselor and you devise a payment plan to repay your creditors, you have to also submit that payment plan or repayment plan if it was completed within 60 days of the filing of your petition. And I'll just note parenthetically about the credit counseling. Again, you have to go to the bankruptcy court's website, and then it's the bankruptcy court that serves the district in which you live. Find the approved list, find one that's closest to your home. But also know that many of the credit counseling agencies will allow you to do the credit counseling over the phone, over the internet, using your computer, possibly even now mobile devices. Or if you prefer, you can go into the office, sit down with a credit counselor, and complete the counseling in person. It's entirely up to you how you do it. But the moment you complete that credit counseling, the credit counseling agency will produce a certificate with a serial number on it. They will email that to you or your attorney, and then you can file that with the court at the same time you file your petition. In addition to all of the schedules, your petition, your credit counseling certificate, you also have to pay your bankruptcy filing fee. And you'll recall when we went to the bankruptcy site, the fee to file a bankruptcy is $335 for Chapter 7. You have to pay that fee also at the time you file your petition, or your petition will be denied. Now, many people who file Chapter 7 do not have $335, in which case you can complete a waiver form. And in order to receive a waiver of the bankruptcy filing fee, you have to demonstrate to the court that your annual income is less than 150% of the poverty level. Now, there is an installment option when you pay your bankruptcy fee where you can pay a portion of it up front and pay the other portion within 2 weeks of filing. But if it turns out you can't even afford to do that, then the bankruptcy court may grant you a waiver of the filing fee, in which case the filing of your Chapter 7 will be at no cost to you. Now, after you complete the means test, which is the most important place when you start your bankruptcy, because if you can't satisfy that test, numerous problems ensue in terms of trying to be able to satisfy or overcome the presumption of abuse of the code. The next most daunting aspect of a Chapter 7 is the numerous forms you have to complete, which require specificity, accuracy, and honesty. As a result, preparing to file a Chapter 7 can require a lot of homework and sometimes a very feverish search for documents to be able to provide accurate numbers necessary to complete all of these forms. So I usually advise people to start off by ordering their credit report from all 3 credit reporting agencies. These reports together should hopefully list every creditor that you have that has made a report to a credit reporting agency. But you also need to list things that you know are debts that are not listed on your credit report. For example, if you owe a relative money, you need to list that on your forms as well. You also need to list court judgments, if any, which sometimes do not appear on credit reporting forms. And as I'll mention towards the end when we talk about the court denying the discharge, failure to list creditors can be fatal to your discharge. So you want to make sure you list any person that you owe money or you think you may owe money on those forms. There's no harm in listing someone that you may not owe, but not listing someone that you owe can be fatal to your case. In addition to the persons you owe or the entities that you owe, you need to list the source, the amount, and the frequency of your income. And this includes income to which you may have a right to enjoy in the future, but that you may not have at this time. You'll have to list every piece of property you own. I mentioned this, I believe, in the first video, where if you have jewelry or any asset that you choose not to list on the schedules because you think maybe it's not important or it's not really worth anything, and you're discovered later, this can be fatal to your Chapter 7 as well, because everything you write on those schedules is offered to the court under penalty of perjury. And I can assure you the bankruptcy court takes it very seriously. And I can't tell you how many times people have either omitted things accidentally or because they didn't think it was worth mentioning. And this omission or these omissions were later discovered by the trustee. This is a position you do not want to be in when you're asking the court for relief. You'll also have to make a detailed list of all of your monthly living expenses, including food, clothing, shelter, utilities, every penny that you're spending. And that also includes expenditures for medical bills, medicine, or other healthcare expenses. This leads to the next really important aspect of your Chapter 7, and that is property that you are allowed to keep after the Chapter 7. This is known as exempt property. Now, exempt property is treated in one of 3 different ways. First, the Bankruptcy Code, specifically Section 522 of the Bankruptcy Code, enumerates specific pieces of property and the values of those pieces of property that you can exclude from the bankruptcy estate, meaning you can keep those pieces of property after the bankruptcy is over and no one can come after you and try to later take those pieces of property. Now, the Bankruptcy Code has a list of items, but some states have taken advantage of a provision in the Bankruptcy Code that allows the state to determine what property is exempt and to assign a value or a dollar amount to that exempt property. Then the third potential category would be states that allow you to choose between the federal list of exemptions or the state list of exemptions. And savvy attorneys and persons who understand the code, whether they be attorneys or not, are going to always opt for the list when it's available to you based on where you happen to live. that allows them to keep the absolute most amount of their property. But this area is also fraught with danger, because if you were to miscalculate or misread the statute or take a liberty that is not afforded to you by the statute, that miscalculation can cost you a piece of property that you may have otherwise been able to have exempted from your bankruptcy estate. But by way of illustration, Section 522 of the Bankruptcy Code allows you to exempt $15,000 in real estate or personal property, $2,400 in one motor vehicle, $400 in any particular item, or $8,000 in the aggregate in household furnishings, household goods, and wearing apparel. So most of your household furnishings and your clothing, your televisions, things like that, the computers are going to be covered by this particular $8,000 exemption. You're also allowed to exempt up to $1,000 in jewelry that's held primarily for your family or your personal use, $800 plus $7,500 of any unused portion of your $15,000 personal property exemption. That was the first one I mentioned. And this $7,500 is sometimes what we refer to as the wild card. So if, for example, you had $2,000 in jewelry, you can apply the $1,000 exemption specifically set aside for jewelry used for personal use or by members of your family, and add to that $1,000 up to $7,500 to cover the other portion of your jewelry, which is not covered specifically by the jewelry exemption. You can also exclude from the bankruptcy estate $1,500 in value for implements, professional books, or tools used in your trade. You're also allowed to exempt from the bankruptcy estate any unmatured life insurance contract that you own, as well as $8,000 of any unmatured life insurance contract. Now, after all of your schedules are filed and approved by the bankruptcy court clerk, there's going to be a meeting of creditors. But I want to talk a little bit about filing with the bankruptcy court. For over a decade, all federal filings have been done electronically. This includes the bankruptcy court. Now, that doesn't mean you still don't have to have physical schedules, because you do. In fact, if you're called to a meeting of creditors, you will need to bring with you the actual forms printed out and signed. In fact, the original signature needs to be visible on your bankruptcy petition. However, almost everything that happens in the bankruptcy court is done electronically. So you simply download the forms from the bankruptcy site, complete the forms, sign the forms if necessary or if that's required, and then you upload the forms to the bankruptcy court's website. Now, in order to be a filer in bankruptcy court, you really need to have two different kinds of accounts. The first kind of account is called a PACER account, P-A-C-E-R. PACER is a website used by federal filers to access and view documents filed in any federal court in the Republic. Anyone can get a PACER account. You simply need to go to the website and sign up for it. Because of this, everything that's filed with the federal court is visible or discoverable by anybody with an internet connection who's willing to go ahead and get a PACER account. Now, these accounts are essentially free if you download documents up to probably 50 pages. After that, PACER will start assessing a fee for any document above the 50-page limit. But that being said, anyone can go on and view your bankruptcy schedules, and you can certainly view anyone else's bankruptcy schedules, as well as other documents filed with the federal court. So that's a PACER account. But in order to file a document with the federal court, you will have to have an actual e-filer account. The bankruptcy court will allow you to create an e-filer account, provided you follow all of the instructions and all of the rules associated with the e-filing process. This account is essential in order to be able to create a new account or to open a new case and to file into an existing case. And when you file documents using the federal court's e-filer system, the e-filing clerk will examine those documents. If those documents are deemed to be deficient, you will receive by email a deficiency notice. That deficiency notice will give you a specified period of time to correct or cure the deficiencies noted by the e-filing clerk. If you fail to do so, your petition, if it's been filed, could be dismissed. And as a matter of fact, if your petition is dismissed, the court may find that your failure to comply with the clerk's instructions to correct or cure a deficiency was willful. If the court makes that finding, you will not be able to refile for 180 days. Now, assuming all of your documents were filed properly and accepted by the clerk, between 21 and 40 days after your petition is filed with the court, the trustee of the court will hold a first meeting of creditors. Now, I've talked about the first meeting of creditors before, The first meeting with creditors occurs in something more like a conference room than a courtroom. As a matter of fact, you may never see a bankruptcy court judge unless a creditor institutes what's known as adversarial proceedings, during which they object to the discharge of a particular debt, or there's an allegation that you are attempting to abuse the bankruptcy code in some way. But you will most certainly see the trustee at the first meeting of creditors. At that meeting, you are to bring with you all of your schedules, including your petition, originally signed by you. If your spouse is a joint filer, he or she must also attend. When you enter the room where the meeting of creditors is being held, you'll find numerous other individuals who are there for the exact same purpose. And sometimes you'll see individuals seated there carrying briefcases and wearing suits. And those are probably attorneys representing creditors who intend to question debtors during that meeting. You also have to bring your social security card and your driver's license or state ID. The trustee will typically conduct these hearings alphabetically. When your name is called, you approach the table with all of your documents. You show the trustee your social security card and state identification. Thereafter, the trustee will administer an oath, and he or she will ask you if everything in your schedules and in your petition was true at the time you filed your petition, and if those schedules and those statements in your petition and schedules remains true today. That being done, there may be other questions asked of you. After the trustee is done with any questions he or she may have, attorneys for your creditors may also have questions for you. Now, as I indicated earlier, you have to provide prior to the meeting of creditors, and usually at the same time you file everything else with the court, all of your schedules and your petition, detailed information about your income and your assets. This includes income tax returns and pay stubs for the last 6 months. Sometimes the bankruptcy court refers to pay stubs as payment advices. But prior to the first meeting of creditors, the presumption is that all of your schedules and all of the documents required for the trustee to be able to effectively administer the bankruptcy estate have been provided. And that includes tax returns or transcripts from your tax returns, usually for the last 3 years, and including any tax returns to become due during the pendency of your petition. And as I mentioned, pay stubs for the last 6 months. Now, the bankruptcy trustee's role is to be impartial and to administer the liquidation of all of your non-exempt assets. During this series, I've talked about the distinction between secured debts and unsecured debts. Secured debts are debts in which the creditor was given a security interest in that property. And what that means is that along with your promise to repay, you promised that if you were to default on that loan, the creditor was then entitled to certain collateral that you pledged to guarantee that you would pay the loan back. Secure creditors enter into bankruptcy on a much higher level of priority than non-secure creditors. Non-secure creditors are people like credit card companies in which they simply loaned you or extended you a line of credit, and then you went out and bought things using that line of credit. There's no collateral pledge guaranteeing that you'll pay them back. It's just simply your name on the dotted line. Secure creditors, on the other hand, have the right to place a lien on and, if necessary, seize property if they were to obtain a court order to do so, or in the case of a vehicle, they can repossess that vehicle or that item without breaching the peace. But the trustee's primary job, again, is to liquidate all of your non-exempt assets. So after you applied all of the exemptions that were mentioned, anything for which there is not a valid exemption can be sold for the benefit of your non-secured creditors. So then what happens is that bankruptcy cases become either asset cases or no asset cases. A no asset case is one in which either all of the property is exempt pursuant to one of the valid exemptions that we talked about, or the secured creditors have all been satisfied in accordance with their security agreements, and frankly, there's nothing left to sell. Those are no asset bankruptcies. Asset bankruptcies are bankruptcies in which people enter in with, let's say, 4 or 5 Rolex watches, and there's no exemption that will cover even one of those typically. In such case, those watches are going to be sold by the trustee for the benefit of creditors. Now, if it turns out that your bankruptcy is an asset bankruptcy, then unsecured creditors are required to file a claim with the court within 90 days of the first meeting of creditors. However, if one of your unsecured creditors happens to be a governmental unit, the governmental unit has 180 days to file a claim. The other thing that a trustee has are known as avoiding powers. Avoiding powers allow the trustee to claw back certain payments that you made prior to the filing of your bankruptcy petition. Those are sometimes referred to as preferential transfers. So, for example, if you owed your father-in-law a sum of money and you chose to pay your father-in-law back that sum of money prior to filing your Chapter 7, and it's later discovered that you did that, then that money that you paid to your father-in-law will be clawed back by the bankruptcy court trustee and reapplied to your debts held by unsecured creditors. Now the question then becomes, how would the trustee find out if in fact you did such a thing? Well, there's a very methodical and sometimes shrewd analysis of your finances. And I can assure you, the trustee and even some of the lawyers who might represent creditors who may object to either your discharge of their debt or to entries on your schedules on the theory that you're not disclosing everything that you have. But your bank accounts or your bank account records could be called or into question or subpoenaed. And if every penny you've earned, and let's say the last 90 days prior to filing bankruptcy, or if there's a sum of money that's not accounted for, that's visible either in your tax returns or from a pay stub, let's say you received a bonus from work and that sum of money is not accounted for by an expenditure or a purchase, folks are going to start wondering what became of that money. And that's how people get caught in bankruptcy court, because sometimes they get too cute by half and they think they can either outsmart or outrun the process. And that, of course, is a fool's errand, because you're dealing with people who do this for a living. Thus, the problem becomes if you fail to disclose that transfer to, say, your father-in-law, and it's discovered by either the trustee or another interested party to your bankruptcy proceedings, this can be characterized as either perjury, meaning you did not disclose that when you were required to do so, or it could be interpreted as an attempt to defraud creditors. In either case, it could jeopardize your bankruptcy case, and your case could be dismissed, and you could be barred from refiling, or you could face criminal prosecution as a result. So again, every aspect of your financial dealings needs to be fully disclosed, even if you think it may not be relevant, because someone may determine it is in fact relevant, if for no other reason because you chose not to disclose it. Now, assuming again, all of your schedules were filed timely, accurately, you've complied with all of the requests and directives of both the court clerk, the bankruptcy trustee, and the judge, if such a request was made of you, you will be entitled to a discharge. And the good news is that 90% of the debtors who file Chapter 7 do experience a discharge of their debts and receive a fresh start. And that discharge usually happens within either 60 or 90 days of the first meeting of creditors. So if you emerge from the first meeting of creditors with no requirements being made of you, and if your case was filed properly, all of your schedules were clear and accurate, and there are no irregularities in anything you filed, chances are you'll get up from the table having met with the trustee with nothing left to do but your financial management course. Now, financial management is a course that you have to take after the first meeting of creditors, and it is slightly different from the initial credit counseling course that you took prior to filing. Now, I often tell people before they file Chapter 7 and sign up for the credit counseling course, to inquire of the approved credit counseling agency whether or not they can pay for both courses at the same time. Oftentimes, if you pay for both at the same time, you'll get a discount, because the credit counseling agency knows that you're going to need both in order to experience a discharge. So it's always wise to pay for them both at the same time, and you'll often get a reduced price. Those are the happy cases when people are able to actually walk out of the bankruptcy court with a fresh start and no debts to speak of other than debts they chose to keep. And which debts might a person choose to keep? Well, the biggest, of course, is the mortgage. Many people enter Chapter 7 thinking they're going to lose their house, and although some people do, many people do not, because of what's known as a reaffirmation agreement. Now, you'll recall me talking about the automatic stay, and after you file Chapter 7, creditors are no longer able to deal with you directly or speak to you at all about any debt. In fact, they must cease all collection activity altogether, lest they be found guilty of violating the automatic stay, which sometimes can carry very hefty fines. But any debt that you had prior to the day you filed your petition, it's included in the bankruptcy estate, and if you receive a discharge of that debt, it's gone forever. Thus, if you have a mortgage going into a Chapter 7, that mortgage is going to either be discharged or it's going to be reaffirmed after you file your Chapter 7. Now, going into a Chapter 7 with a mortgage affords you two opportunities. One is you can have the debt discharged and you can walk away from the home free and clear, or you can choose to stay in the home, in which case you must reaffirm the debt. Now, reaffirmation is a process that requires you to complete an additional set of forms which bear on their face all kinds of disclosures about your rights and responsibilities and your understanding in going into a reaffirmation agreement with your creditors after your bankruptcy petition has been filed. Now, typically, these reaffirmation agreements will include, if not mirror, the terms that you already signed in your mortgage. It's just a different set of documents, but the interest rate will typically be the same. Sometimes it's even a point or two lower. The payments are usually what you were making. It may even be lower, but whether or not your interest rate remains the same or is lower is really a matter that's negotiated between you and your creditor, in this case, the mortgage company. But if you elect to reaffirm the debt you have, and it is not just limited to mortgages, it can be any debt in which there's a contract moving forward and collateral in your possession that you choose or would like to keep. That reaffirmation agreement has to be feasible based on the income you have remaining moving forward. And it also must be assigned by you, the creditor, and the bankruptcy court judge. Many people, especially some of those folks who elected to represent themselves in bankruptcy court, miss this step, and it becomes a horrible nightmare when they emerge from bankruptcy court thinking somehow that their mortgage was discharged, and yet they get to remain in their home. That is not at all how it works. There is no such thing as coming out of bankruptcy court with a free house. If you do not get that mortgage reaffirmed before your bankruptcy is discharged, you may find yourself in foreclosure proceedings shortly after your bankruptcy court discharge and wondering how this could have happened. Well, this is how it happens. You have to get, and it is your responsibility to get that reaffirmation agreement done before you actually emerge from bankruptcy court. And done means it's signed by everybody, including the judge. However, once a reaffirmation agreement is done and signed by the judge, it's entered into the court record, you simply need to make payments as agreed in that document. But that, of course, is your option. You do have the option of walking away from the home, essentially scot-free, and owing nothing, provided the judge allows you to discharge that debt. And that might be the biggest debt you have. And of course, the motivation for doing that is that if you don't do that, and there's a deficiency after the sale of your home, the lender may pursue other recourse in order to cure that deficiency. So getting that behind you and not having enough to worry moving forward is what a fresh start is all about. What grounds, if any, might a court have for denying you a discharge? Well, there are about 7. The first is when you fail to keep or produce books or financial records required or called for by the court or the trustee. You can also not receive a discharge if you fail to satisfactorily explain the loss of assets. You can fail to receive a discharge if you commit perjury. You can fail to receive a discharge if you fail to obey a lawful order of the bankruptcy court. You can fail to receive a discharge if you fraudulently transfer items. And how that manifests is someone decides that before they file bankruptcy, they're going to retitle their assets in someone else's name, or they're going to simply gift away assets prior to filing bankruptcy with the intention of recapturing those items after they emerge with a discharge. If that's discovered, that's considered a fraudulent transfer. And not only could you experience the dismissal of your petition, you could also experience criminal charges as a result of that. Along with that comes concealing or destroying property that would have otherwise become part of the bankruptcy estate. And finally, if you fail to complete an approved course in financial management, the court could elect to not grant you a discharge. And again, part of the motivation behind parts 1, 2, and 3 of this series was to really do a deep dive and determine whether or not chapter 7 or 13 was something that from which you would benefit in the first place. And the main reason why I think that's important is because some of the debts from which people are seeking relief are not dischargeable. For example, alimony and child support are not dischargeable. Many tax debts are not dischargeable. And monies borrowed for purposes of education from either the government or a nonprofit are not dischargeable unless there's an extreme hardship. What's an extreme hardship? An extreme hardship requires you to pass a 3-prong test. The first prong in that test is that your current income and expenses are such that you could not repay the educational loan and maintain a minimal standard of living for yourself and your dependents. Prong number 2 requires a showing of additional circumstances that indicate that whatever hardship you're experiencing is going to continue for a significant period of time. And finally, the third prong requires that you have made a good faith effort to repay the loan. So if you haven't made any payments on your student loans, that alone is going to cause you to be impaled on the horns of this particular test. So I typically tell folks when they have student loans, you might want to plan to keep them because it's very hard to pass that three-pronged test. The fourth category of debts that you cannot discharge are consumer debts made to a single creditor totaling more than $725 for luxury goods or services. Now, that's an important distinction to make, because if you incurred debt in the excess of $725 for things that were necessary for yourself or your family, food and clothing, utilities, things like that, then that particular test does not apply. Fifth on the list is that if you had an open line of credit and you used that open line of credit and expended it to the tune of $1,000 or more within 70 days of having filed bankruptcy, that debt is not dischargeable. If you were involved in a malicious injury of someone else or their property, and there are costs associated with that malicious injury, those costs are not dischargeable. If you were driving under the influence and someone was injured or property was damaged and there were costs assessed for that, those costs are not dischargeable. And of course, if you were involved in a criminal proceeding and restitution was imposed by the court, at the conclusion of that proceeding, that restitution is not dischargeable either. There's another category of debts that's not dischargeable, but for this category of debts, the creditor has to come forward and complain within 60 days of the first meeting of creditors. And then three of these. The first one is if you obtained a loan of money by way of making a false statement to the creditor. The primary example of this is where someone embellishes their education or work experience in order to induce a creditor to loan them money. If those false statements or that embellishment is discovered later and it is determined by the court that it was that lie that induced the creditor to loan you the money, and that creditor comes forward timely, namely within 60 days of the first meeting of creditors, that debt is not going to be discharged. And as a matter of fact, if the court was to find the deception egregious enough, your petition can be dismissed in its entirety. The second category is outright deceit or fraud, which might be slightly different, but not entirely distinctive from, let's say, embellishing some facts. And the third is when you maliciously destroy property of an entity or a person. Now, the only thing that might dissuade or discourage a creditor from coming to the court and making the allegation that you embellished facts or that you lied or you somehow committed fraud to induce them to loan you money is the fact that the creditor has to show that their position is substantially justified. If they're not able to meet that test that's determined by the court, they're going to be stuck paying your attorney fees if you have an attorney. So that might be a powerful disincentive for someone to bring a case that is not ironclad, indicating that you somehow or another obtained a loan using false pretenses, fraud, or deceit. And finally, I mentioned this in the beginning, if you fail to list a creditor in your bankruptcy, subsequently receive a discharge, and that creditor later finds out that they were not listed and as a result did not have notice of your bankruptcy and could not therefore participate and perhaps argue that your debt to them should not be discharged, the court could then, upon a finding and a reopening of your bankruptcy case, find that that creditor's debt or your debt to that creditor is not discharged or not included in the bankruptcy estate, and therefore you still owe it. So that's why I indicated earlier that you have to list everyone to whom you owe money, even if you're not sure if you still owe it, because failure to do so could result in that person later coming back and crying, saying, I never was told, and therefore this person should not be able to escape what they owe me. But the Sixth Circuit has said that if it's a no asset bankruptcy, that's a Sixth Circuit federal court, has said that if it's a no asset bankruptcy, the fact that they were not listed is of no consequence, because had they been listed, they still would have gotten nothing. But that is not every federal court that has that position. So the safer position is to simply list everyone and everything to whom you owe money and seek to have that debt discharged along with everything else. Well, that concludes my series on surviving financial challenges during the COVID-19 era. I hope you enjoyed it, or at least found some aspects of this very helpful to you. If you did, please share it with other individuals who might also benefit from the information. I hope that few, if any, people have to actually access this information to overcome a challenge. That is to say, I hope that everyone remains safe and is able to overcome this pandemic without financial hardship. And I also ask, if you have any questions regarding the information provided in this series, please submit those questions to me. I will do my best to answer those questions. And please subscribe to the channel. Thank you. God bless.